Good morning and welcome to the Public Service Commission of South Carolina. It is Thursday, May 23rd at 9 a.m. and we are here to resume the hearing in consolidated dockets 2023-388E concerning Duke Energy Carolina's application for an increase in rates, and docket number 2023-403E concerning Duke Energy Carolina's petition regarding ongoing grid improvement plan. Let's see, we did appearances the other day. I think we're ready to get started, but are there any preliminary matters we need to discuss before we start taking testimony? Hearing none.
Chairman.
Excuse me, I'm sorry, Chair.
You got to be quick.
I know, Chair, I know.
We're moving today now. Let me just tell you, we're going to keep going today, so.
I support that,
Get my
Chair.
attention. You did good. Get my
Thank
attention,
you.
any of you.
I support that, Chair. So really quickly, Chair, in terms of an introduction, I have one additional introduction today. That's Molly Jagannathan of also Troutman Pepper. I note that Molly has also been admitted pro hoc vice in this proceeding. And then, Chair, the other thing that I wanted to highlight, whether now or later on, but as I'm sure the Commission and the parties are aware, the settlement agreement includes a provision we're all supporting, and non-objection parties agreed to stipulate into the record without cross-examination the testimony and exhibits of witnesses for the settling and non-objection parties who filed testimony in this case. Further, yesterday, both the DCA and the company made a filing that included essentially a consensus order of witnesses that further refines that list for the parties to reflect the input of the DCA. Therefore, at the appropriate time, Chair, the company would propose to mark for identification and enter at least the company's testimony and exhibits in the consensus order of witness list into the record as if given orally from the stand.
Or do you want to do that now or at when we kind of get to it?
Chair, I defer to you as to the time. I at least wanted to highlight it.
We'll start with the live witnesses.
Okay.
Is that correct? Any disagreement on what was just stated? Okay.
That's correct. I do have a follow-up question.
Mr. Elliott?
Thank you, ma'am. We have proposed submitting, as the letter reflects, certain verified testimony and stipulating it into the record. However, we are mindful of the fact that the Commission may have questions of the witnesses that we propose to stipulate. At least as far as I'm concerned, if my witness is to be stipulated in the record, but if there's some desire to hear from him, I need to address some scheduling issues with him next week.
Okay. Let us get to a break or lunch and we'll let you know.
Yes, ma'am.
Okay.
Thank you.
I know that there are some witnesses that have conflicts today or need to be heard today or tomorrow. Have the parties been able to work out if we have to take those witnesses out of order?
Yes, Chair, at least from the company's perspective.
That's okay. So just let me know when we get to a point where we need to take somebody out of order, so I don't skip over them. I would ask, we've got a lot of lawyers, so if you would identify yourselves when you speak so that the court reporter can make sure she's crediting the correct person, I think that would be helpful.
Yes, ma'am.
If you would.
Thank you.
And I need to do a roll call of commissioners and present in the hearing room. We've got Vice Chair Powers, we've got Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. I note for the record that Commissioner Justin Williams is on military leave and is not participating in the hearing. And with that, I think we're ready to go. Everybody okay? Mr. Robinson?
Thank you, Chair. At this time, the company would call Michael Callahan, Retha Hunsaker, and LaWanda Jiggets.
Swear you in, and I'll start with you, Ms. Jiggets. If you'll raise your right hand. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Mr. Callahan, do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. And do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. Mr. Callahan, good morning.
Good morning.
Would you please state your name and business address for the record, please?
Michael Callahan, 40 West Broad Street, Greenville, South Carolina, 29601.
And by whom are you employed and in what capacity?
Duke Energy as South Carolina State President.
Mr. Callahan, on January 4th, 2024, did you cause to be pre-filed in this docket direct testimony consisting of 29 pages?
I did.
And did you on April 22nd, 2024, cause to be pre-filed in this docket rebuttal testimony consisting of 31 pages?
I did.
And did you on May 22nd, 2024, cause to be pre-filed in this docket amended settlement supporting testimony consisting of 11 pages?
I did.
Do you have any changes or corrections to your pre-filed direct, rebuttal, or amended settlement supporting testimony?
No, I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Okay. I would move, Chair, that Mr. Callahan's pre-filed direct, rebuttal, and amended settlement testimonies, as previously described, be entered into the record as if given orally from the stand.
Mr. Callahan's direct testimony, rebuttal testimony, and settlement testimony will be entered into the record as if given orally from the stand.
Thank you, Chair. Ms. Hunsaker, good morning.
Good morning.
Would you please state your name and business address for the record, please?
My business address is 525 South Tryon Street. I work for Duke Energy Corp., and my title is Senior Vice President of Customer Experience Design and Solutions.
Ms. Hunsaker, I'm sorry to interrupt, but I know you want to look at who's asking you the question. I need you to speak into the microphone, please.
Okay, thank you.
Thank you.
And Ms. Hunsaker, on January 4th, 2024, did you cause to be pre-filed in this docket direct testimony consisting of 38 pages?
I did.
And did you on April 22nd, 2024, cause to be pre-filed in this docket rebuttal testimony consisting of 10 pages?
Yes, I did.
And did you on May 16th, 2024, cause to be pre-filed in this docket settlement supporting testimony consisting of 7 pages?
Yes.
Do you have any changes or corrections? Okay. It sure did. Thank you. Do you have any changes or corrections to your pre-filed direct, rebuttal, or settlement supporting testimony?
I have no changes.
All right. And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
All right. Ms. Hunsaker, have you prepared or caused to be prepared under your supervision one exhibit labeled as Hunsaker Direct Exhibit 1?
Yes, I did.
All right. Thank you. And do you have any changes or corrections to your exhibit?
I do not.
All right. Ms. Chair, I move that Ms. Hunsaker's pre-filed direct, rebuttal, and settlement testimonies, as previously described, be entered into the record as if given orally from the stand, and that her Hunsaker Direct Exhibit 1 be marked and entered into the record.
Ms. Hunsaker's direct testimony, rebuttal testimony, and settlement testimony will be received into the record as if given from the stand. Ms. Hunsaker's Exhibit 1, I believe that accompanied her direct testimony, will be, find my list, marked as the next hearing exhibit, which will be hearing exhibit 10, marked for identification and entered into the record of this case.
Thank you, Chair. And Ms. Jiggets, good morning.
Good morning.
Ms. Jiggets, would you please state your name and business address for the record?
LaWanda Jiggets, 410 South Wilmington Street, Raleigh, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as a Rates and Regulatory Strategy Director.
Ms. Jiggets, on January 4th, 2024, did you cause to be pre-filed in this docket direct testimony consisting of 50 pages?
Yes, I did.
And did you on January 23rd, 2024, cause to be pre-filed in this docket supplemental testimony consisting of 9 pages?
Yes.
And on April 22nd, 2024, did you cause to be pre-filed in this docket rebuttal testimony consisting of 55 pages?
Yes, I did.
And did you on May 16th, 2024, cause to be pre-filed in this docket settlement supporting testimony consisting of 9 pages?
Yes, I did.
Ms. Jiggets, do you have any changes or corrections to your pre-file direct, supplemental direct, rebuttal, or settlement supporting testimony?
Yes, I have a couple of changes to my pre-filed rebuttal testimony. On page 21 of that testimony, line 2 should be a 5-year amortization period pertaining to our recommendation for the hydro sale. Also on page 21, line 9 should have been a 3-year amortization period pertaining to our recommendation for the AMI amortization period. And lastly, on page 42, line 17 should be 90 basis points of impact.
Ms. Jiggets, if I asked you the same questions here today, would your answers be the same?
Yes, they would be.
On to exhibits, Ms. Jiggets. Have you prepared or caused to be prepared under your supervision 12 total exhibits labeled as Jiggets Direct Exhibits 1 through 4, Jiggets Supplemental Exhibits 1, 2, and 4, Jiggets Rebuttal Exhibits 1 through 4, and Jiggets Settlement Exhibit 4 that were previously filed with the Commission as attachments to your pre-filed testimonies in this docket?
Yes, I did.
Do you have any changes or corrections to your exhibits?
No, I do not.
Chair Belzer, I move that Ms. Jiggets says pre-file direct, supplemental direct, rebuttal, and supplemental testimonies as previously described be entered into the record as if given orally from the stand, and that her direct, supplemental,
Okay,
rebuttal, and
let's do the,
I'm
okay.
sorry. Go ahead.
I'm slow. Let's do the testimony.
Okay,
Thank you.
sure.
Ms. Jiggets direct, pre-file direct testimony, supplemental direct testimony, rebuttal testimony, and settlement testimony will be entered into the record as if given from the stand.
Thank you, Chair. Chair, the company also requests that the direct exhibits 1 through 4, Jiggets supplemental exhibits 1, 2, and 4, Jiggets rebuttal exhibits 1 through 4, and Jiggets settlement exhibit 4 also be marked and entered into the record.
Madam Chair.
Mr. Torrey?
Just a clarifying matter. ORS has addressed this with the company with respect to Jiggets Settlement Exhibit 4. It is a list of the pro forma adjustments that would be implemented as a result of the increase. ORS is continuing to review the accuracy of that. So, and I believe the agreement is that any necessary revisions would be handled before filing the proposed order.
And Chair, we have no objection to that.
That the supplemental exhibit was prepared in response to the settlement agreement to conform her exhibits to what was in the settlement agreement. Is that correct?
That is correct. Yes.
And ORS is still trying to
Confirm the accuracy.
confirm those. Okay.
It's a rather lengthy exhibit.
It is. I think we had one commissioner that found a question on something, so you may get a question on that. So,
Madam Chair?
Mr. Hall.
Yeah, sorry, Roger Hall, the department. I would just ask that if there are substantive changes or any changes, that if ORS or Duke or the company can notify all parties of those changes.
Definitely.
Provide time to comment if necessary.
Thank you.
Chair, that will not be a problem.
Parties will be notified of any changes and be allowed appropriate time to comment. Thank you. Okay, so Ms. Jiggets, I got too many lists up here. Hang on with me. Where's my exhibit list? Okay. Are you offering these as a composite exhibit?
Chair, I was. However, we're happy to separate those out as well if that's easiest for the commission and the parties.
Okay. Why don't we do the Ms. Jiggets direct exhibits 1 through 4, supplemental exhibits 1, 2, and 4, and rebuttal exhibits 1 through 4 as a composite exhibit, and then the settlement exhibit 4 will be a separate. So, let's see, direct exhibits 1 through 4, supplemental, direct, and rebuttal will be marked for identification as hearing exhibit number 11 and admitted into the evidence of this case. The settlement exhibit 4 will be marked for identification as hearing exhibit 12 and admitted into the evidence of this case, subject to comments from the parties should there be changes that need to be noted.
Noted, Chair. Thank you.
Thank you.
Okay. Mr. Callahan, did you prepare a witness summary for purposes of this hearing?
Yes, I did.
Ms. Hunsaker, did you?
Yes, I did.
And how about you, Ms. Jiggets?
Yes, I did.
Okay. Can I ask you all to please read them, please beginning with Ms. Jiggets first, then Ms. Hunsaker, and then ending with Mr. Callahan. Thank you.
Good morning, Chair Belzer, Vice Chair Powers, and other members of the Commission. My direct testimony discusses the results of the company's operations under present rates on the basis of an adjusted historical test period consisting of the 12 months ending December 31st, 2022. I address the additional revenue required as a result of the cost of service based on the pro forma costs in the test period. I also discuss several pro forma adjustments to the company's test period operating expenses and rate base. Additionally, I provide the capital structure used in developing the revenue requirement in this case. Moreover, I discuss the company's proposal to mitigate the rate increase to customers. I also explain the accounting request the company is making in this case, including its request for an accounting order to allow for continuation of the regulatory asset treatment for coal ash basin closure compliance costs. In my supplemental direct testimony, certain accounting and pro forma adjustments that contained projections in the company's application were updated with actuals as I indicated they would be in my direct testimony. I also updated certain accounting and pro forma adjustments based on circumstances and events that occurred after the company made its original filing. The proposed resolution of these issues are reflected in the settlement agreement. In my rebuttal testimony, I respond to certain accounting and rate-making issues proposed by the ORS. The proposed resolution of these issues are reflected in the settlement agreement as well. On May 17, 2024, I filed settlement testimony supporting Attachment A to the settlement agreement and explaining that, with the exception of the Department of Consumer Advocate, all parties support or do not object to the settlement agreement covering all issues between the settling parties in this case that, subject to this Commission's approval, would permit the company to adjust its South Carolina retail base rates and tariffs to produce additional sales revenue of approximately $240 million effective August 1, 2024, based on a capital structure of 51.21% equity, 48.79% debt, and a cost of debt rate of 4.56% and a return on common equity of 9.94%. As a part of the settlement agreement, subject to Commission approval, DEC will accelerate the return of deferred income tax benefits resulting from the Federal Tax Cuts and Jobs Act of 2007 through its excess deferred income taxes, or EDIT rider, such that it will produce an annual revenue requirement decrease of approximately $84 million, partially offsetting the base rate revenue increase through July 31st, 2026. Accordingly, if approved by the Commission, the net revenue increase effective August 1, 2024 would be approximately $156 million. Attachment A, which consists of settlement versions of 3 exhibits included in my direct testimony and prepared under my direct supervision or control, provides the details supporting these calculations. Company witness Morgan Beveridge will explain how the proposed increase in revenues supported by my testimony and Attachment A translates to customer bill impacts. In my opinion, the settlement agreement represents a just and reasonable resolution of the issues in this proceeding, reflects a constructive approach to providing necessary rate relief that will allow the company to maintain its financial strength and is in the public interest. This concludes the summary of my pre-filed testimony.
Thank you. Ms. Hunsaker?
Good morning, Chair Belzer and members of the Commission. I'm the Senior Vice President, Customer Experience Design and Solutions for Duke Energy Corporation, including Duke Energy Carolinas. In my role, I lead the design and execution of end-to-end strategies for measurement, valuation, and improvement of the customer experience. I oversee customer marketing, engagement, and analytics, as well as the development and optimization of technology solutions that transform how our customers experience and interact with Duke Energy. In my direct testimony, I highlight our customer service efforts and how that translates to customer satisfaction. I also describe several steps the company has taken to further improve the experience and satisfaction of our customers when they engage with us, including the deployment of our new customer information system known as Customer Connect, new web forms, mobile app capabilities for outage reporting, a dedicated street light repair tool, more information, customer communications, and other enhanced solutions that provide greater convenience and control over customers' energy consumption. At Duke Energy, the customer and communities are at the center of our purpose. As I describe in my testimony, we work to build genuine connections with all customers by listening, taking note of evolving expectations, anticipating their needs, and offering solutions. I also discuss the company's level of customer satisfaction. Our efforts were recently recognized by J.D. Power's Customer Satisfaction Index, showing DEC was a top quartile performer nationally in 2021, 2022, and 2023. As stated in my testimony, it is both an honor and a privilege to be a service provider for so many South Carolina customers. We will continue working diligently to ensure we meet our core purpose every day. I also had the privilege of attending all of the night hearings held by the Commission. I would like to personally thank every one of our customers who came out to express their views on the company's rate request. Our team of representatives were on site to help address customers' questions and concerns. We heard each of them and took their issues seriously. I am pleased that we were able to communicate with most of the customers directly and have either resolved or are working to resolve their concerns. I recently filed a letter in this docket summarizing our efforts. I'm available to answer questions the Commission may have regarding these customers. Finally, on May 17, 2024, I filed testimony in support of the comprehensive settlement agreement reached with the majority of the parties in this proceeding. If the settlement is approved, the company agrees to a shareholder contribution of $1 million to conduct a low-income affordability study and convene a working group consisting of interested stakeholders, including interested stakeholders or interested participants from the EE Collaborative by the end of next year. In coordination with this working group, DEC will evaluate a broad spectrum of regulatory programs and protections for low-income customers, ranging from affordability programs, potential new tariffs, and other initiatives. We are looking forward to working with interested stakeholders to further define the scope, timeline, and goals related to this effort and report back to the Commission. This concludes a summary of my testimony. Thank you.
Thank you, Ms. Hunsaker. And Mr. Callahan.
Good morning. My name is Mike Callahan, and I am the South Carolina president of Duke Energy, including Duke Energy Carolinas, which is the subject of today's hearing. Chair Belzer, Vice Chair Powers, members of the Commission, I am pleased to appear before you today to put our rate application into perspective and provide insight into the company's future priorities. A rate case is a complex undertaking and serves a vital role in the service to our customers in South Carolina. I would like to thank this Commission, the Commission staff, the Office of Regulatory Staff, and all other parties in this proceeding. I would also like to thank my colleagues and all those involved in working hard to put a serious, thoughtful, and balanced case in front of this Commission. And just as importantly, I would like to thank our customers, particularly those who attended the 7 public hearings throughout the state to voice their opinions regarding the company's rate request. The energy sector is in a period of transformation and change driven by technological advancements, environmental and regulatory mandates, extreme weather, storm activity and response, energy security and resiliency efforts, as well as evolving customer expectations. We are taking steps to keep pace with these changes, and this rate application reflects our efforts to respond to the specific needs of our South Carolina customers. As the company pursues an orderly transition towards achieving a diverse, more secure energy future, the voices of our customers and our investors have become increasingly clear on this topic. They expect us to have a diverse power supply and are making economic growth decisions based on those expectations. To that end, we have made investments in generation resources like highly efficient natural gas, nuclear, hydro, and solar. We're also making the investments necessary to support coal ash basin closure activities in compliance with federal and state requirements. All of these actions are beneficial for the state and our customers, and the company is appropriately seeking recovery of its prudently incurred costs. Reliability and resiliency remain essential to our customers, which is why our investments in diverse, highly efficient generation resources, our transmission and distribution grid, smart meters, and the tools we use to communicate with our customers are more critical than ever. We continue to work on new and improved, streamlined options and versatility for customers, driven by information about how they consume energy and by tools that help them manage their consumption. We know how important electric service is for our customers, and no one wants to see bills increase. To ease the impacts of these investments on our customers, we took steps in our initial filing to go ahead and help mitigate impacts to customers. This included taking steps to delay the filing of the company's application. It included maximizing operational efficiency and cost-saving measures without sacrificing our level of service. And it included our proposal to flow back to customers on an accelerated basis excess deferred income taxes. That said, I am proud to present for this Commission's consideration a settlement agreement that is comprehensive in the scope of issues it addresses among the settling parties. The agreement includes the Office of Regulatory Staff, South Carolina Energy Users Committee, Southern Alliance for Clean Energy, Coastal Conservation League, Vote Solar, and the South Carolina Small Business Chamber. And the settlement is unopposed by Walmart and CMC Recycling. If the agreement is approved, it would resolve all disputed issues between the settling parties in this case, and among other things, reduce the company's requested revenue increase by $83 million. Additional key terms of the settlement include continuing deferral treatment for future coal ash compliance costs, stopping deferral treatment for grid improvement plan costs, disallowing a portion of incentive compensation, and resolving recommendations related to the Duke Energy Plaza. The settlement includes an agreement not to appeal previously ruled upon motions regarding coal ash compliance costs totaling $36 million and an additional disallowance of $17 million related to additional coal ash compliance costs in this proceeding. There are also several non-revenue requirement-related terms, such as the requirement that DEC perform enhanced reliability, storm, and vegetation management reporting. Finally, the agreement includes a $2 million shareholder contribution to fund a low-income affordability study in South Carolina and low-income weatherization programs. As the Commission is well aware, this case was extremely complex. As evidenced by the number of parties and witnesses in this case, the volume of testimony filed, and over 2,500 discovery requests received and addressed. We engaged in extensive negotiations with all parties for several weeks to get to this point, and I cannot thank the parties enough for their willingness to listen to each other, to collaborate with each other, and ultimately to negotiate with each other. I can confidently say that all parties, each with different interests, derive benefits from this settlement, and that this agreement is a true representation of compromise. As such, it is imperative that the Commission evaluate this comprehensive settlement agreement not by the individual components, but by the totality of the terms. If just one of the provisions in the settlement agreement is modified, the careful, balanced resolution created by the parties may tilt. By the terms of the settlement agreement itself, any changes would allow any party to withdraw their consent. As I close my remarks, let me end on a critical concept, and that is the notion of balance. Under the laws of this state, we have the obligation and privilege to serve our customers and to do so safely, reliably, and affordably. In return, as a regulated, investor-owned utility, we need the ability to recover our prudently incurred costs, as well as an opportunity to earn a fair and reasonable return. The settlement, therefore, also allows Duke Energy Carolinas an opportunity to earn a return on equity of 9.94% and an equity component of the capital structure of 51.21%. This is important as the company must maintain its financial strength and access to capital necessary to provide safe and reliable service to a growing population of customers in the fastest growing state in the nation. I believe that the settlement agreement represents a fair, reasonable, and comprehensive resolution of the issues in this case, is in the public interest, and results in just and reasonable rates. The company respectfully asks that the Commission approve the settlement agreement in its entirety. This concludes the summary of my testimony in this proceeding.
Thank you, Mr. Callahan, Ms. Hunsaker, and Ms. Jiggets. Chair, the panel is now available for questions for cross-examination and questions from the Commission.
Thank you. I believe these parties to the settlement agreement have foregone. Does that also include non-signatories who are not objecting to the settlement agreement?
Yes, it does.
Thank you. Mr. Hall or Mr. Edwards for the DCA.
Thank you, Madam Chair, and for the court reporter. My name is Roger Hall. I'm the Deputy Consumer Advocate of the Department of Consumer Affairs. I may need to use the Elmo at some point in time. I don't know if I'll be able to figure out if we need to warm it up or anything like that, but so it looks like it's on. I'll just look around the room when
They're shaking their heads. I think if you put something on there, it's on.
Okay, great.
And if we need to bring somebody up, we will.
Okay, might be a few minutes.
It won't be me, I can guarantee you that.
I understand. Okay, Ms. Jiggets, good morning. I'm going to start with you, if that's okay. You are the Rates and Regulatory Strategy Manager for Duke Energy Carolinas, correct?
Correct.
Okay. And I'm assuming this means you could answer general expense-related questions?
Depending on the nature of the correct questions, correct?
Okay, well, we'll see. Do you know, this is a sort of an odd one you may not know off the top of your head, but do you know the total amount spent by Duke Energy Carolinas between this rate case and the end of their prior 2018 rate case?
Can you say that one more time, please?
Do you know the total amount spent by Duke Energy Carolinas between this rate case and the end of their last rate case?
With respect to what type of expenses are you asking?
All expenses.
I do not know the answer to that
Is
question.
that number in any of your settlement agreement or any of your documents you've submitted? I mean, is that a number that's possible to figure out?
I would assume it would be possible to figure out looking at financial statements for that time period, but that is not part of my testimony. My testimony would have focused on the test year as adjusted in this proceeding.
Sure. Understood. I thought that one you might not have that off the top of your head. Do you know the operations and maintenance revenue collected by Duke Energy Carolinas during the test period?
Operations and maintenance revenues?
Mm-hmm. Revenues related to any operations maintenance expenses that are being recovered or deferred or any carrying cost?
The amount of operations and revenues operation and maintenance expenses that would have been collected would have been based on what was awarded in the last case, whatever their O&M level was as a result of that case. I do not have that number in front of me, but that's what would have been reflected in rates during the test year, is that level of O&M.
Gotcha. And I think this might be the same answer then, but during the test year, do you know how much total revenue was collected from South Carolina ratepayers through rates?
With respect to what's allocated in the cost of service, or?
Yes.
I believe that may be reflected in one of my exhibits. Let me just check. Per books, electric operating revenue before adjustments was 1.9 million. I'm looking at settlement exhibit, page 1. It's Jiggets exhibit 1.
Jiggets Exhibit 1, Settlement Exhibit 1?
Yes.
And what was that number?
The per books electric operating revenue was 1896067 as allocated to South Carolina retail operations.
Thousands, millions, billions?
That would have been in thousands.
1.9
So 1.9 billion.
1.9 million? That's the only revenue that was collected from South Carolina ratepayers during the test year?
1.9 billion.
Billion with a B. Okay, 1.9 billion. I thought million sounded low. Okay, thank you. So generally, rate making is pretty complicated, isn't it?
Yes, it is.
And that's kind of reflected in the 258-page exhibit that you have that shows Duke's, for the settlement, that shows all the revenue and customer allocations and things, right?
The exhibit that you're referring to, that's just the adjustments that we make to the test year balances. But
So that's just the adjustments, 258 pages, and that PDF is of a spreadsheet that probably has lots of formulas, and it's lots and lots of spreadsheets combined into that PDF, right?
that PDF comprises, I believe we made something around the lines of 40 individual adjustments in the case, and so that PDF has all of the support behind those adjustments, correct?
Gotcha. And so part of that, this is part of the reason that parties submit testimony throughout the case. Oftentimes hire experts so that they can explain all those adjustments and things, right? So we get a little bit more information behind just numbers, correct?
I would agree with that.
So I think you just alluded to it, but I want to make sure I understand. Would you say that your settlement exhibit captures all of the revenue and cost impacts of the settlement?
Yes, Settlement Exhibit 4 basically reflects the impacts of all of the adjustments we proposed in this case and reflects the terms of the settlement agreement that we reached with all the parties.
Okay. And then you had, if I recall, there were, so not beyond Exhibit 4, there was attachment A to the settlement that is an updated version of your Jiggets Exhibit
1 through 3.
1 from your supplemental direct testimony, correct?
Correct. So as a part of my initial testimony, I had 4 exhibits. Exhibits 1, 2, and 3 were part of attachment A to the settlement agreement. Exhibit 4 is the details, and again, it's the mirror of what was Exhibit 4 in my initial testimony.
And these numbers, your testimony talks about some of them also, right?
Yes.
Okay. One you talk about is the cost of capital numbers, is that right?
Yes, I discussed what numbers were used and the calculations and how they.
And have you seen ORS witness, Mr. Lawyer? Have you seen his settlement testimony?
I have not.
Have you heard the number that it resulted in $41 million in savings?
I have not.
Okay. Would your exhibits, whether attached to the settlement or your or the 258-page Exhibit 4, could that number be figured out from all the numbers and pages in that document?
I'm not sure where his number comes from, but what my exhibit will show you is how when we initially filed this case, I asked for a $323 million increase. My Exhibit 4 shows you how we get from that $323 million increase down to the $240 in this proceeding. That's what my Exhibit 4 will support.
And off the top of my head, that's closer to $83 million.
Yes.
Okay. Let me show you that. So what two exhibits? So I was going to show you your settlement attachment A, Jiggets Exhibit 1, compared to your Jiggets Supplemental Direct Exhibit 1. Does that sound right?
Okay.
Okay. I have copies of these. If anybody, the other attorneys, specifically the Duke attorneys, I can, if you'd like one. Yes. I was going to put them on the Elmo, but I'll have Mr. Edwards.
Thank you.
And let's see, I do have one more. Let me make sure I keep myself straight. So that was your supplemental Exhibit 1, and this is going to be the settlement attachment. And I put this document on the Elmo also for the benefit of the commissioners. Hopefully, I may need to zoom in a little bit. Not sure if I need to press a button.
Tell me again which exhibit you're putting up there.
This one is Supplemental Direct Exhibit 1.
Thank you.
And I know that's why I had a feeling these numbers might be a little small. Let's see if I can zoom in. I only want to look at a couple. I think that'll just about do it. So actually, let me back up just a little bit. Well, so Ms. Jiggets, this document, it kind of reflects what I always kind of refer to as the general revenue, or sorry, the rate of return calculation. I assume you're familiar with it, but basically you would multiply the capital structure times the respective cost of debt and return on equity, right, to get an overall rate of return for each.
Yes.
So I don't think that number is shown here. I believe, but you kind of see it here. So I'll just see if I can talk into the microphone and draw on this. So right there where I've circled, actually, so the company originally submitted in their request a 10.5 ROE. We see that on the far right, correct?
Correct.
And then a 4.56 cost of debt.
Correct.
Okay, and what is the 4.12 that's over there to the left?
So what the 4.12 represents is before we make any proposed adjustments, our revenue requirement, our operating revenue with our adjustments would be 320 million that you see reflected here. Once you take into account that 4.5% that's needed for long-term debt, that takes 158 million. We're left with 161 million for equity investments. And so the 4.12 is just derived by calculating what's left.
Okay. So I usually look at it a little bit differently, but that's okay. So we have your 4.56, and then if I can, over here, we have the 47% capital structure, the debt part of the structure that was originally submitted in your application, right?
That was our proposed cap structure, correct? And
And
we
then-
allocated the rate base based on that proposed cap structure.
Right. So, and you have 53% what you proposed. So I'll try to explain it, and you just tell me if I'm wrong. So basically, you would, again, multiply the 47% times the 4.56, gives you a certain number. You multiply 53% times 10.5%, that gives you a number. You add those up, and that's your overall rate of return, correct?
In terms of what's over in the far column.
Yeah, I didn't see it. That's kind of where I was going. There isn't a percentage number there that I saw on this exhibit.
So
at
the
least.
41,755 is derived just how you had stated, where it's by taking the retail rate base times the 53% proposed cap structure times the 10.5 rate of return. That gets you to the 411,755.
Right.
But the 412 is calculated how I described earlier, where it's literally looking at, based on what we have, what you know you have to use to satisfy debt investors, what's left. And that's why that 4.12 is significantly less than the 10.5.
Okay. And when you say satisfy investors, so that's 411,755,000 in income on rate base, basically.
That would have been what was needed to supply to provide a return to our equity investors.
Okay, thank you. Okay, now let's see. So I'm going to actually mark. So we're looking at 411. Okay, so here again, this is the settlement proposal. And we have the 48.79, 51.21 for the revised capital structure. We have cost of debt remains the same, and then we have 9.94 for the ROE. And this time we are looking, is this right, if it's 546,185 number? Or actually, you know what, let me, answer that, please, I'm sorry, I'm getting ahead of myself. Sorry.
So the 546 would be the total return.
Right, and so, okay, let me go back to the other exhibit, apologize to everyone. There, it was, your proposal was 570 million would have been the total. And so 570 minus the 546, that's 25 million, so still not quite to the 41 million that Mr. Lawyer testified to, is that right?
Subject to check.
Okay.
Again, I haven't done that math.
Okay. And so I guess just want to understand there's no way to verify the 41 million from your 258 pages or the prior exhibits?
Again, I have not read his testimony, so I can't speak to how his number was calculated.
I'm not asking if you know how he calculated. I'm asking, could you calculate it from looking in the 258-page document or any of the other exhibits?
Without knowing what his number represents, I can't speak to that. I don't know.
How would you determine the savings from that results from the settlement?
I think the savings from the settlement are actually illustrated in an exhibit to the attachment A. It actually provides a detailed walk down of our initial ask in the case to the revenue requirement that we've agreed upon for
Okay,
each
and
pro
looking
forma
at that
adjustment.
document, can you
It's about the $83 million that we discussed earlier.
say that number again?
It's around $83 million, and I'm referring specifically to exhibit, well, it will be a part of attachment A for the settlement, and I'll get to the exact page for you. It's about attachment A, it's page 14. That provides a detailed walk down of all the impacts of the settlement agreement on the revenue requirement ask. It starts with the original $323 million that I asked for in this case. It shows the impact of my settlement updates, which took the ask up slightly, the amount that we could support in this case up slightly, but then provides a walk down of the impacts of all of the
I'm sorry
settlement
to
terms.
interrupt, but could you give me that page number again?
For attachment A, it's page 14 of 18.
Thank you.
It's part of Jiggett's Exhibit 1.
Thank you.
You're welcome.
Okay, pretty big difference. So I'm gonna try to see if we can understand how $41 million. I'm gonna give something to your attorneys and make sure they're okay with it first. So Ms. Jiggets, what I'm showing here are, I believe, all the numbers that we have talked about so far, and maybe some others that are in your testimony. And what I've tried to capture, if I can get it all on the screen, I know it might be a little small for everybody, is that if you look at the bottom, so we see the 47% debt and the 53% equity that was requested in the application. We see the 10.5% requested ROE, 4.5%, 6% cost of debt. And we talked about the multiplication to get to the overall rate of return. And subject to check, would you see that it says 7.71%, the very bottom there?
Yes, I see that.
And my understanding is there is a gross up for taxes, is that right? Where,
Yes.
so there's a 21% federal tax rate and 5% state tax rate. So subject to check, I'm showing that as 9.66. At the top of the page, I'm showing the settlement proposal. So again, we have a 48.79 that we talked about, the 51.21, the 9.94 ROE. Multiply those, add them up. You have a 7.31, 7.315. So I asked about the 7.32 number. I believe I'd seen that. It may not have been in your exhibits, but subject to check, does that seem right?
Subject to check.
Okay, and then with the tax gross up 9.104%. Subject to check, would you agree?
Subject to check.
Okay. Now, we have the chart in the middle. That's a little complicated, but I'm trying to walk you through it. We have the rate base requested in the settlement is $7,466,453,000. Does that sound right?
Yes, that sounds correct.
And you'll see that box in the middle. We have settlements. It labels here the rate of return portion, but essentially you would multiply the 9.104, 9.1, let's say, times 7,466,453,000, and you would get this number. Subject to check, would you agree that's how it is done, how that number is derived?
Subject to check.
Okay. Now, I will admit the number below it, the DEC proposed, I do believe is the 7,466,000,000 times the 9.66, the overall rate of return, but in the ballpark. So you see the difference there is $41.8 million, correct? So again, subject to check, you subtract those two numbers and say this is what the revenue was under the application versus under the settlement, and pretty close to Mr. Lawyer's number, correct?
Chair Belzer, apologize. I just want to make sure that Ms. Jiggets is having enough opportunity to be able to review and validate and compare and contrast those numbers to confirm that they are accurate, given the nature of the testimony.
And I will say I'm happy to give her the time. I do not plan to submit this into the record. I'm using it demonstratively just to show a summary of all the numbers and figures that are in the various testimonies in Ms. Jiggets' Exhibit 4 and the attachments to the settlement agreement.
If she needs time to review, she can take the time that she needs to review it.
Can you walk me through your middle part of this calculation again, please?
Sure. So under the settlement, the $679 million number is the $7.466 billion figure times the grossed up for taxes rate of return of 9.1%. And the 721, admittedly, I do believe that is the same 7.466. Well, I'll be back up. The rate base requested in the application was 7.399 billion, so roughly 7.4 billion. Is that right?
Yeah.
Mr. Hall, do you have a pen or a pointer that you can point to these numbers?
Sorry.
I'm having a little trouble following.
Sure.
And I want to understand what's going on.
Sure.
too.
I was hoping it would simplify all the.
Okay.
So tried to boil down.
I think that would help.
258 million.
That's going to help me
pages.
if you can point to what you're talking about.
Sure. So and Ms. Jiggets, please correct me if I'm wrong. You were asking about this part in the middle here. And so here was settlement. Here we had the 679 million would be derived from multiplying the rate base in the settlement, let's call it $7.466 billion times the overall rate of return after it's been grossed up for taxes. And then this number, which probably should be admittedly the $7.399 billion that was requested in the application times, again, the grossed up rate of return number.
I think a more accurate, a way that would make more sense to me is to actually compare the exhibits that you gave me previously, because that's reflective of how we calculate them in this case. I think if you wanted to look at what we were asking for in this case in terms of what the rate of return difference impacts were. You would just compare what would be my Jiggets Exhibit 1, the pages you gave me previously, between settlement and initial testimony or settlement and supplemental update and settlement and rebuttal, because it shows you the numbers, and I can easily tie it back to what I've done in my pro formas and can walk you through it from that perspective.
Well,
this is not how I'm familiar with looking at and doing that analysis. and so
Fair,
that would
fair
be-
enough. And I can ask Mr. Lawyer, maybe one of the other
Yes.
ROE witnesses about it. Let me just ask you one more thing. Would you agree, though, that as this rate of return number here increases or decreases, excuse me, the ROE number increases or decreases, it's going to change the rate of return number? If the ROE number goes up,
Any changes in capital structure or the cost components will change the outlying or the derived rate of return.
and then that will ultimately impact the calculation that's done there in the middle too, as far as.
It
the
would.
revenue. Okay, thank you. So either way, whether we're talking about 41 million, 85, I forget your exact number, 85 million, I mean, we're talking big dollar figures, correct?
Correct.
Yeah. As we said, as those numbers fluctuate and change, those are going to add up quickly to greater savings for the customer, correct?
Any changes will impact the customer's amounts, correct?
Thank you. So I want to ask you a little bit about deferrals. There's a lot of discussion in the testimony about deferrals. Would you agree?
Yes, there was.
Okay. Do you recall that ORS witness Brasino testified that $80 million of the company's request, or 25% of the company's total request, was related to deferrals?
I do recall that.
Okay. Do you agree with that number?
Yes, we were able to verify that number.
Okay. And those deferrals were related or requested for both coal ash remediation efforts and grid improvement plan expenses, right?
I need you to face the microphone
Oh,
when you
okay.
answer, please, ma'am. I'm sorry.
No problem.
Thank
Those were two of the deferrals that were included in this request.
Okay. And the settlement has some provisions about both?
Yes, the settlement has provisions about both.
The grid improvement plan deferral is going to end, as I understand it. Is that right?
Correct. The grid deferral will end as of August 1, 2024.
And the coal ash deferral, it's going to continue. Is that right?
Correct. The coal ash deferral will continue.
Okay. And the settlement provides for a debt return during the deferral period and a WACC, or weighted average cost of capital, return during an amortization period. Is that right?
With respect to coal ash and grid, correct.
With respect to coal ash and grid improvement plan, that's correct, right? Thank you. And the company requested a WACC, or again, weighted average cost of capital return for both the deferral and amortization period, didn't they?
We requested the full carrying cost return for all of the deferrals in the proceedings. So for the environmental, ARO, grid, all of them.
The settlement also provides for some longer amortization periods, I believe, than were originally requested. Does that sound right?
Only for certain deferrals. For coal ash, environmental ARO, 7 years was proposed. That's what we ended up with. A longer amortization period was agreed upon for grid.
Okay. And these changes, again, comparing to what the company requested versus the settlement, those are all positive for the customer, right? They're going to result in lower costs for the customer?
I wouldn't the impacts in this case are lower because we're stretching the recovery out over a longer period of time. However, the customers will ultimately still be paying us the same amount.
Their current monthly bills will be lower than they
Their
would.
current
All
monthly
else equal,
bills,
their monthly bills will be lower from having a debt return during the deferral period as compared to a WACC return during the deferral period.
yes. The deferral amounts did go down based on the terms of that settlement.
Right. And I believe Mr. Callahan and I mentioned Mr. Lawyer with ORS before, they both mentioned these deferral changes in their settlement, right?
In their
Yes,
settlement.
Mr. Callahan, you're here. You mentioned the deferrals in your settlement testimony, correct?
Yes, I believe that's correct.
Okay. And you state on page, I'll go ahead and ask you, I guess this is better for you than Ms. Jiggets. On your page 6, lines 13 to 14 of your settlement testimony, you do state, give you a second, and I'll quote, and just tell me if I'm wrong, that the adjustments will significantly reduce the amount of deferred costs the company is authorized to recover associated with coal ash basin closure. Is that correct?
Yes, that is correct.
Okay. And I guess next couple questions maybe for both of you. You don't mention a number for those customer savings, do you?
I don't believe I have that in my testimony, but I believe it would be in the adjustments.
It is. You can see that, again, the impact of that, all of the changes to the recovery for the ARO and that, again, settlement exhibit that I referred to that has the walk down.
Is there, I admittedly, I don't have all those right in front of me, but is there a number that you can point to that is the savings from the reduced carrying cost on the deferrals?
I do not, it is not specific to just the reduced carrying costs. I have the impact of all of the settlement terms, which also included removal of $36 million of costs from the prior case and $17 million of costs in this case. I do not have it isolated to just the return impacts.
Yeah, because deferrals affect a lot of things, right? Affects depreciation, maybe taxes, lots of different line items and things in your 258-page exhibit are impacted by the deferral changes. Is that right?
The deferrals each have their own calculation. So if you wanted to see the impact of the changes on individual calculations, you would just look at each deferral itself and you could see the changes. So if you wanted to see what changed with the environmental remediation pro forma, you would go to that pro forma 4010 in Exhibit 4, and you could see the adjustments that support the revised amount. And it would have a summary of what changed based on the settlement agreement. Not dollar amounts, but it would tell you the nature of the changes that were made.
Okay, and I think I know the answer to this question based on what you've said, but you probably could not give us a ballpark figure of the impact, could you?
I cannot.
Okay. And you think that'd be something important for the commission to understand, what the impact of this reduction is?
I think if the commission wanted to see it again, the best way to do that would be to take a look at, again, pro forma 4010 and compare it as of settlement to what it was and as initially filed, and you would see the impacts of the amounts coming out.
And again, so that reduction is going to be primarily from changing the WAC return during the deferral to a cost of debt return during the deferral, right?
Not with regard to environmental ARO, because there were also significant amounts that came out of the request based on the settlement. Again, we took out $36 million and $17 million from the request as well.
Sure.
And so that's going to impact the changes that you see with respect to return, because when you take those amounts out, obviously the returns are different.
Okay. Well, let me ask it this way. The lower the return during the deferral period, the greater the customer savings, all else equal. Would you agree? Instead of a cost of debt during the return, 4.56 during the deferral period, if the commission ordered no return during the deferral period, customers would see savings. Is that right?
If there were no return included, like, yes, that would be a reduction in the amount that we're.
And if they submitted a 2% return instead of 4.5% return during the deferral period, that would be more customer savings, right?
Based on how the calculation is prepared, yes, that would be. But again, that return would not allow us to appropriately compensate our investors who have provided the funds for the expenditures for those deferrals during that time period.
What is that time period?
From January 1 of 2019 through August of 2024. So a pretty long time period where our investors would have supplied the funds for everything flowing through those deferrals. So in terms of if it's a capital expenditure or if it's an expense, like we would have collected that money from an investor and they would expect a return on it. So anything, a zero return doesn't allow us to provide our investors.
I understand.
Compensation.
So it's been 5 years, those have been accumulating for 5 years, correct, the deferrals?
Yes.
Okay. And company can come in every 12 months for a rate case, right?
So I've been told, but again, the timing for a rate case, we have been out for 5 years. Our timing is not out of line with other utilities. That I did take a look at that. We have come in on a pretty regular cadence that's consistent with other utilities in the area. Our timing is not out of line with Dominion just came in for another case as well, and I think they have been out for 4 years. So it's not like we've been out for a very longer period of time compared to other utilities here.
And if I could, some of the factors that go into that, we're mindful of the economic environment that we've been operating in. When is a good time to come in for a rate case? As I said in my comments, there's no good time to come in for a rate increase. Deferrals have been a useful tool for us to stay out of rate cases. And effectively, through those deferrals, allow us to take into account customer impacts. I mean, you think about the 5 years since 2018, we were dealing with COVID. That was not a good time to come in for a rate increase. And so I just want to at least say that that's an aspect of it. Has been 5 years since we came in, but there were considerations and drivers around why we waited.
And I understand that, and I understand COVID caused a lot of problems and supply chain issues and things like that, right? We've also heard from various witnesses that there was historically low interest rates from about mid-2020 to 2022 or somewhere in that. Does that sound familiar?
Yes, that's correct. I think the Fed responded to the macro environment, the fact that the economy had been weakened, and they did that by basically lowering interest rates to historically low levels.
And so if you look at near zero rates versus the 4.56% cost of debt here, I mean, that's a pretty big difference that maybe if you came in sooner, then that number could get adjusted down lower?
Well, I think that would be included either way because the debt that we issued to fund these costs are in the 4.56%. We certainly took advantage of the capital markets during that time, issuing as much debt as we could to fund our operations. In fact, that's why if you look at our current debt rate in rates of 4.53%, it's only moved by 3 basis points because we took advantage of those low rates on behalf of customers.
Understand, thank you. Ms. Jiggets, I think the next few are actually directed to you, Mr. Callahan. Obviously, y'all are all on the panel together, and feel free to chime in if you want to. So again, Ms. Jiggets, there was also a lot of discussion in this case about the grid improvement plan. Would you agree?
I would agree.
And this is something the company has spent billions of dollars on, is that right?
Subject to check. I don't get into the specifics of the investments in my testimony.
And some of those costs are included in this case?
We have the grid deferral component that's in this case, and then the investments in the assets themselves would be in the case, correct?
And there was a lot of discussion about how much was spent on each program. Would you agree? Or Mr. Callahan, would you agree that the testimony covers a lot of expenses that were incurred on the grid improvement plan programs?
Yes, it certainly it includes detail on what we spent on. I think witness Guyton can talk through that at greater depth than either of the two of us can, but yes.
Okay. And there was also a lot, or some, I won't say a lot, there was also testimony about whether certain programs were cost beneficial or not. Do you recall that?
Yes, I believe that's the case.
Okay. Ms. Jiggets, are the grid improvement plan programs shown in your settlement exhibit?
With respect to recovery of the deferral, yes.
With respect to cost recovery, are they reflected at all? You tell me, how are the grid improvement plan programs reflected in your exhibits, if at all?
As I just stated, like you would see the impacts of the assets themselves are just going to be included in the various capital performance that are in this case, and then the recovery of the grid deferral is reflected.
Are they broken out by program? I know there are several.
They are not broken out by program.
Okay, so there's no way to determine the actual cost, the revenue impact from each individual program?
No, not within the context of my pro forma adjustments. For the overall assets themselves, no.
Okay. And so again, those costs through the deferral or through otherwise direct cost recovery are impacting customers' rates in this case?
Yes.
Okay. And so if the commission did find that some of those costs were either unreasonable or not used and useful or imprudent or any of the other things they look at those costs and they disallowed some or part of them, that would also lower customers' bills, wouldn't it?
Any adjustments proposed by the commission would impact the requested recovery in this case. But again, we've reached, I think, as you know, a settlement, most of the parties. To my knowledge, there were no adjustments proposed by anyone that I needed to reflect in the pro formas. We did make an adjustment, I believe, to remove $2.5 million of targeted underground costs that were removed from the pro forma for recovery in this proceeding. But aside from that amount, there are no other adjustments to costs associated with the grid program and the settlement agreement.
Sure, and you're aware that the department's testimony was that 42 million of the tug cost should be removed, right?
Subject to check. I'm not familiar.
Mr.
with that
Callahan, do you agree that was our testimony?
Yes, I agree.
TCS testimony? Thank you.
Which, by the way, was 100% of the targeted undergrounding,
I understand.
targeted undergrounding costs.
I understand. So I want to, excuse me, I'm going to go back to Ms. Jiggets. So step back, look at the big picture a little bit, Ms. Jiggets. So the company's proposal would have increased the average residential bill by $30 starting in August 2026. Is that correct? From where it is now, August 2026, I believe the number I saw was that it would be about $30 increase per month for the average customer.
For the initial application?
No, just by, if you're looking at today's numbers and then August 2026, everything else stayed the same.
You're asking after the EDIT rolls off,
Yes.
correct?
Yes. And so that number, I guess I could have asked them in the other order, but the increase will be would have been $19 beginning this year and an additional 11 in 2026. Does that sound right?
That does not, because I believe it's $19, and then with the EDIT, that brings it down to 6 to be 12, and so when EDIT rolls off, it goes back to the 19. But that's a better question to ask for witness beverage.
Okay. Mr. Callahan, do you have an opinion on that question?
I don't know the numbers in the original filing, and I'm not sure,
I don't know the original.
LaWanda, if the number that you gave was the settlement number.
I believe it is the settlement
'Cause
number. My
those-
numbers
I
are the
recognize
settlement.
those numbers
I'm
from the
going to ask
settlement.
about that next. So,
Okay.
Excuse
can we
me,
agree
Chair,
that-
I'm sorry. I've sat for a little bit of time here. I would really appreciate if Mr. Hall would allow my witnesses to answer the question fully before he interrupts, please.
I apologize. I'll take my time. Just remind me anytime, Mr. Robinson.
Thank you, Mr. Hall.
Thank you. And so Mr. Callahan, you alluded to it. The reason for the two numbers is that the company has proposed to accelerate the return of EDIT, or excess deferred income tax.
Yes, that's correct. So in the filing itself, very similar to what we proposed in the Duke Energy Progress case, we proposed that we flow back to customers effectively the excess deferred income taxes that we've recovered from customers prior to the Tax Cuts and Jobs Act, where we were booking taxes at 35%. Tax Cuts and Jobs Act reduced that to 21%. As a result, we had excess deferred taxes that it's customers' money, and we had previously been amortizing that over a 20-year period, had 16 years remaining on that, and we proposed to help moderate this bill increase over the next couple of years by flowing that back to customers over 2 years.
So I think you said this, but so basically the mitigation is just giving customers their own money back sooner.
Sooner than had been authorized by this commission in the 2018 rate case, yes.
Okay. And so let me ask, admittedly, this is something that I didn't fully understand, but I think Ms. Jiggets may have alluded to it. With the acceleration, that extra money will be gone in August 2026, so then the customer's bills go back up. Is that right?
When that give back portion of the EDIT rider expires, just the base rate impacts will remain on customer bills.
Okay. And then I believe with ORS's testimony, you said these numbers earlier, the average residential bill will increase $12.53 this year instead of roughly 19 as proposed by the company. Does that sound right?
The 18 is without the EDIT mitigant.
Right. So this year, residential bills under the settlement will increase average customer $12.53
Correct.
Yes.
per month. And then once the EDIT runs out, the bill will increase another $6.40.
That sounds correct.
Okay. And that is for the average customer who uses 1,000 kilowatts per month. Is that right?
Yes.
Yes, that's correct.
Okay. So anyone who uses more than the average is going to obviously see higher increases, right?
That's correct. And by definition, those who use less will see lower.
Right. Correct. And that 19 in the settlement versus 30 that under the proposal, that's pretty good, you would agree, right?
Sorry, could you ask the question again?
So comparing the savings the settlement provides, $19 per month versus $30 a month, that's pretty good for the customers, right?
It's certainly lower than what we requested in this case for our prudently incurred costs.
And so would you agree that if the commission authorized a lower ROE, or a lower capital structure, lower carrying costs on deferrals, or disallowed any of the grid improvement plan costs, the customers would see an even smaller increase?
Yes, I think any adjustment that you delineated would reduce customer bills. And at the same time, it would also tip the balance on ensuring the financial integrity of the utility, a utility that is entering a period of significant capital expenditures around new generation, around grid investments to increase the resiliency of our grid. And so at the end of the day, I personally feel like the settlement agreement is balanced and weighs those options around what is good for customers and what makes sense from a financial integrity of the utility perspective.
I appreciate that. I'm sure those are issues we're going to get into as we get further into this case. Those savings I mentioned would be for all customer classes too, right? Not just residential customers.
Yes, the revenue requirement is spread to all customers.
Okay, appreciate that. Ms. Jiggins, one last thing, and there might be an explanation. Is just really related to the settlement exhibit itself, and something I saw. Just was wondering if it's an error or not. Do you have the entire settlement exhibit 4?
I do.
So I'm looking at when I was looking at the PDFs, it was page 114 of 258.
Okay.
And I'm really just generally curious, that header that says Duke Energy Progress Net Change in Electric Plant, is that supposed to say progress?
It is not.
Okay, just wondering. And then also on page 137 to 139 of 258, there are headers that say Duke Energy Progress Coal Ash Deferral. I assume that's supposed to be Carolinas also?
Yes.
Okay. Pretty sure the numbers are right though?
Yes.
Okay. Ms. Jiggins, I believe that's all I have for you. I have some questions, more questions for Mr. Callahan, but obviously y'all are part of a panel, so if you feel like someone else is better to answer them, please let me know, but just give me just a second. Excuse me. All right, Mr. Callahan, I'm going to start with your direct testimony. I'm looking specifically at page 26, lines 9 to 13. And I think I said lines 9 to 13. You say, quote, historically, because of its financial position, the company has had the financial strength and flexibility necessary to fund its long-term capital requirements, as well as to meet short-term liquidity needs at an economical cost to customers. As such, DEC has been able to obtain cost-effective capital. Is that accurate?
Yes, that's correct.
And so I think you alluded to it, but attaining that capital has allowed you to fund the grid improvement plan and other investments in this docket?
Yeah, a number of investments, the Lincoln combustion turbine, Bad Creek hydro uprates, solar investments, grid plan investments, a number of investments, Customer Connect, AMI meters, have all been funded through the capital markets, yes.
Over the last 5 years since your last rate case?
That's correct.
And with an ROE of 9.5?
That is correct. An ROE that was allowed an opportunity to earn a 9.5%. As we filed in this case, I think our current ROE that we are actually earning is 4.32%.
And a lot goes into that. A lot of this expenditures and the expenses y'all made will obviously sort of reduce, what you can make, right? If you spend more, based on that, you're going to earn less, right?
That is right. As the rate base goes up and we're not recovering those costs, the rate of return goes down.
would it be fair to say that if you had spent less, your ROE, your rate of return might have been higher?
When you're saying spent less, are you talking about capital investments, or are you talking about operations and maintenance, like more expenses?
Let's say capital expenses for now.
So capital expenses, if we spend less capital, certainly would reduce and it would result in a higher rate of return. But I can tell you that these investments that we're making have been prudently incurred, and they're the necessary investments that we need to provide reliable service, affordable service, and that high-quality service that our customers expect.
And that reasonableness and prudence, those are things the commission will have to decide as part of this case, right?
Absolutely.
Yeah, thank you. Continuing on page 27, lines 19 to 22, you seem to kind of confirm some of the things you just said. Give you a second to get there. You say, quote, as a result of maintaining a strong balance sheet and a constructive regulation that has recognized the need for an appropriate rate of return to Duke Energy's investors, DEC has enjoyed strong and cost-effective access to capital for years. Is that right?
Yes, that is correct.
And I might just let you read this one just to take a break from my voice. If you don't mind. So continuing on page 27 to 28, could you read lines 22 to 23 and then 1 to 6?
Given our ongoing need for tremendous amounts of investor-supplied capital now and in the coming years, the Commission's decisions in this proceeding regarding the company's return on equity, capital structure, and the timely cash recovery of its costs will be critical. As witness Fetter explains in his testimony, constructive regulation should provide a utility with the confidence to make capital-intensive investments and incur expenses for the benefit of its customers, with the reasonable expectation that prudently incurred costs will be recovered in a timely manner. Would you say through 8?
That was perfect. Thank you. Appreciate it. So I want to ask you, when you say reasonable expectation that prudently incurred costs will be recovered in a timely manner. I'm going to show you this. I don't think there should be any objection to it. I do not have other copies for the attorneys, but it's, I will submit, it is essentially the basic revenue requirements formula. Are you familiar with that generally, Mr. Callahan?
I'm generally familiar. I've witnessed Jay gets here, who is probably intimately familiar with it.
Well, if you're not comfortable, or if neither of you can answer, we'll move on. But let's see. So again, you would agree it's sort of the basic formula on how revenues are set.
That looks to be the case.
Okay. And the company's costs are included in this formula, right?
Yes, that is correct. We operate in a cost of service business on behalf of our customers.
And we see here we have expenses, we have operating expenses and taxes. Is that right?
That's correct.
And the capital expenditures you were talking about, those are included in the form of depreciation and rate base?
That is correct.
Okay. And with having depreciation and the rate of return, the formula allows what we often hear as a return of and a return on the investment. Is that right?
That's my understanding, yes.
Okay. Again, the operating costs are distinct from the capital costs. Is that right?
I'm not sure what you mean by distinct.
Well, in the formula, they're sort of, they are accounted for differently, correct?
Okay, understood, yes.
Okay. So when your rates are set, they are set to allow you to recover expenses and capital costs that are prudent and reasonable, right?
That's correct.
As long as those expenses are prudent and reasonable, regardless of how they are funded, rates will be set to allow Duke Energy Carolinas to recover them, right?
Correct. As a part of the kind of the regulatory operating compact, we are allowed to recover our reasonably and prudently incurred costs of operating our business plus the return on the investment in the business. That's what this formula is depicting.
And then the rate of return we see here, that's a component separate from depreciation and operating expenses, right?
Correct. The rate-based formula, the rate-based component of this formula is where it's reflecting the carrying costs.
The return is typically only applied to rate-based items. Is that right?
With respect to this overall calculation, we are recovering, I believe, as you know, as a part of some of our deferrals, we are calculating a return on items that would traditionally be considered operating expenses because those amounts are not being currently recovered in rates, and as Mr. Callahan has alluded to before, are being recovered from our investors in the interim. And so we are including a return component on those deferral calculations, as you are aware.
And you said some of those are items that would be traditionally viewed as operating and maintenance expenses. Is that what I heard you say?
Some of our deferrals do have costs that would be considered O&M. And again, we are recovering. We have included deferrals on those, included returns on those deferrals, particularly the grid, as you know, has an installation O&M component, and we have included returns on that deferral because, again, our investors have provided the funds to support those investments in the grid improvement plan from 2019 forward.
Is it possible to separate the capital components from the operating and maintenance components when you look at your expenses?
For grid?
For deferral purposes, for determining a return. Could one return be applied to the operating and maintenance expense component and another return applied to the capital component?
I don't believe so, but I have to look at the details of the calculation.
Okay. Were you involved in the last Duke Energy Carolinas rate case?
I was not.
Okay. Mr. Callahan, were you?
No, I was not.
Okay. All right, Mr. Callahan, I'm going back to your direct. Page 24, lines 21 to 23. And you state, witness Bauer presents testimony explaining how the company can attract debt and equity investors. Does that sound right?
Yes, that's what it reads.
Okay, and next I'm looking at your direct page 27, lines 9 to 12. And let's see, again, to help save my voice, would you mind reading that for me?
The full sentence.
Yes, please.
The company requires capital to meet these needs, and that capital comes from investors. That sentence.
Yes, and could you, let's see, let me see if I can find, I may have my page number wrong. Okay, this might be easier. So 9 to 12, you just read, I believe, and then could you finish with 17 to 22, that's highlighted below.
DEC competes for capital in the open market and must appeal to Duke Energy's debt and equity investors to attract the capital it needs. As a result of maintaining a strong balance sheet and constructive regulation that has recognized the need for an appropriate rate of return to Duke Energy's investors, DEC has enjoyed strong and cost-effective access to capital markets for years.
Okay. Who are Duke Energy Carolinas debt investors?
Probably a better question for witness Bauer in terms of who they are today. I mean, generally, they're fixed income investors looking for security around investing in a debt instrument, and they want return of capital, and they want a return on the invested capital they're providing to the company.
Okay. And again, if you want to defer to Mr. Bauer, that's fine, but let me just ask you, because I think you're saying the same thing. This would be like entities that buy bonds.
It would be entities that buy bonds. It'd be also entities that participate in commercial paper markets, various forms of debt instruments, yes.
Okay. So who are Duke Energy Carolinas equity investors?
Duke Energy Carolinas equity investors, again, I would probably point to Bauer and Coyne, but it's been 5 years since I've been in investor relations, but I can tell you based on my time in investor relations, it runs the spectrum. When I was in IR, I think 40 to 50% of our investor base was what we called retail investors. So this is the average person directly investing in the company's stock, looking for a dividend, a growing dividend over time. And then the balance was mutual funds, ETFs, et cetera, and other investors that look to the utility space to invest capital.
Okay, maybe I wasn't clear. You said entities or people that buy stock, the company's stock. Can someone buy Duke Energy Carolina's stock?
No, they cannot. Duke Energy Carolinas is a subsidiary of Duke Energy, the holding company.
Okay. So again, I'm back on page 24. This is not what's shown here, but page 24, lines 21 to 23. You see that? Let me see if I can put it up for the commission, I believe. I may not have it, but just remind me, or correct me if I'm wrong. You said witness Bauer presents testimony explaining how the company, now the company I believe you defined as Duke Energy Carolinas, right?
Subject to check, I'd agree with that.
So how the company can attract debt and equity investors. So when you say if the company can attract equity investors, and equity investors are people that buy stock, and you can't buy stock in Duke Energy Carolinas, did you mean something other than the company there?
Well, the equity that we have in Duke Energy Carolinas is provided by our shareholders. The holding company infuses capital to our utilities or takes dividends out that support our external dividend. But no, you cannot buy stock directly in Duke Energy Carolinas.
So you said the holding company, you mean Duke Energy Corporation?
That's correct.
The parent. I might refer to them as Duke the parent. And so if I'm understanding you right, Duke the parent company is Duke Carolina's equity investor.
Subject to check. And I think this is probably a better question for witness Bauer.
Okay, I might ask him as well. I appreciate it. So again, let me just double check. Direct page 27, lines 9 to 10. This one we just had up. Guess I could have left it up. The company requires capital to meet those needs, and the capital comes from investors. So if we're talking equity investors, the company's capital is coming from Duke, the parent, right? So in this statement, those equity investors would be Duke, the parent.
It would also be from earnings that are generated within the utility. But yes, investors here is reflective of both debt investors as well as equity investors.
Okay. And so earlier, one of the lines we looked at said that the company competes for capital in the open market. Does the company compete for capital from Duke, the parent?
I'm not sure I'm following your question.
Let me see if I can find the sentence for you. I can't put my finger on it, but there was a statement. Let me see. Oh, let me find it for you. Same page. I should have just left it up, I guess. So page 27, starting on line 17, you state DEC competes for capital in the open market. So when you say compete for capital, do you compete for it from Duke, the parent company?
Duke, the parent company, competes in capital markets. And as I think about that statement, what that was reflective from my standpoint was we compete for capital with a lot of our peer utilities. So here in the Southeast, for example, I look next door to Georgia Power, an entity that's earning a 10.5% return. I think about Florida, you got FPL with a 10.8% authorized return. I think about north of the border, this very utility recently awarded a 10.1% ROE. So when I was talking about competing for capital, that was what I was referring to, as well as in the debt capital markets, a strong credit rating and entities that want to provide capital to an entity with the credit ratings that we enjoy.
So if I'm hearing you right, and correct me if I'm wrong, does Duke, the parent company, decide where to invest based on who has the highest ROE?
I don't believe that's the case. Witness Bauer can certainly talk more about how we move capital around within the overall family of companies.
So Duke, the parent company, wouldn't decide not to invest in South Carolina because Duke Energy Carolinas has a lower ROE than Georgia, would they?
Like I said, this is, when I was talking about competing for capital, I'm talking about the ability to raise capital to fund the investments that we need on behalf of our customers.
Okay. Give me just a second, please. Pardon me, Madam Chair, I'm just trying to see if I can speed things along or make things more efficient, but quite a few pages left. I'll see what I can get rid of here. Bear with me for just a minute. So, Mr. Callahan, I'm looking at page 22 of your rebuttal. And there are some discussion, and I think you've alluded to it, about what might happen if you're not able to recover your prudently incurred costs or carrying cost. And you say that if credit rating agencies lower the company's credit ratings, it will translate into higher rates for customers. Is that essentially a summary of what you said there on page 22?
I'm sorry, which lines are you on?
So I'll withdraw that question. Okay. I'm looking at page 8 of your rebuttal. And you state at lines 9 to 12, as first discussed in the company's application and direct testimony, the company took numerous measures to delay the filing of this application and offset or lowered customer cost where able. Is that correct?
That is correct. That's in reference to, as I was speaking about a moment ago, the use of deferrals, for example, allowed us to stay out. The fact that we were able to keep our operations and maintenance expense essentially flat over the 5 years was another driver. And then the offset or lowering the costs also included that by the time we filed the rate case, the acceleration of the excess deferred income taxes.
Mm-hmm. And we talked earlier about the sort of historically low Federal Reserve period interest rates from, I believe it was March 2020 to around March 2022. Does that sound right?
Subject to check.
Okay. And it's been part of the company's argument that interest rates drive what the authorized ROE should be. Is that right?
I believe that that's correct. Witness Coyne can certainly speak to the cost of equity models that he uses, but I do believe that interest rates are an input to several of those models.
Mm-hmm. And the company did not come in during that historically low interest rate period to lower their ROE, did it?
We did not file a rate case over the last 5 years, no.
I think that's all the questions I have for any of you.
For this panel? Thank you, Mr. Hall. Commissioners, questions for this panel? Vice Chair Powell, excuse me, is that Commissioner Thomas?
Thank you. Good morning, panel.
Good morning.
Just a little clerical thing in connection with the exhibit by Ms. Jiggett's, exhibit number 4. Again, the reference to DEP as opposed to DEC on page 141, exhibit 4, 258. I assume that that's supposed to be referencing DEP.
Correct.
And the numbers on the page are correct. That's just a little typo.
Correct, Commissioner.
Did you,
All right.
excuse me, Madam Chair, did you say DEP or DEC? Are you saying it should be DEC?
Should be DEC.
Thank you.
And Mr. Callahan, you were talking a good bit about the rates of return for neighboring states and that sort of a thing. You seem to have pretty good knowledge of that. Do you have knowledge of the approved rates of return for the Duke family of companies?
I don't have off top of memory. Like I said, I know North Carolina. Duke Energy Carolina is at 10.1. Duke Energy Progress was 9.8. I don't recall exactly where Florida is. I'm subject to check. It was 10.5% at one time. I'm not sure where the Midwest ROEs are at this point.
All right. In connection with the refund of the excess deferred taxes and the 2-year flow back, I guess my concern there is that just going to these public hearings and listening to customers, and they always seem to have a hard time understanding bills and why the bill goes up and that kind of a thing. I just wonder if it would not have been a little bit more clear to customers if that amortization period were a little bit longer. I mean, I know it makes the bills lower now, but next thing you know, imagine Ms. Hunsaker, your apartment's going to be getting a whole lot of calls and just confusion. What's the balance there? I mean, you said you came in, it hadn't been in 5 years, and it seems like more like 3, 4, 5 years would have helped just overall smooth out customers' bills. Any thoughts on that?
Yeah, and I think the word that you used was balance. And it's very similar to the thought process we had with Duke Energy Progress. In fact, I remember having a similar conversation about we need to be sure that we communicate well with our customers as that EDIT balance rolls off. There's a couple other factors. There's a lot of costs that go into customer bills, as you know. One of those is fuel as well. We're ending a period here where fuel prices have come down. You may recall the last DEC, actually it was 2 cycles ago, we had agreed to effectively amortize the under-collected balance that we had for customers over a 2-year period, helping to moderate the bill impact for customers. We'll be filing, I think, in September for new fuel rates in November, so that was a factor that we were thinking about. We're expecting a decrease there. And then in the longer term, under the Inflation Reduction Act, the nuclear production tax credits, this is something that is incredibly beneficial to the Carolinas because in Duke Energy Carolinas we have 7 nuclear units. And they're incredibly efficient and low cost, and the way the tax credits work, there was incentives around those that are most economical, if you will. And we think that we can generate hundreds of millions of dollars of tax credits for our customers, and we'll have the ability here in the settlement, if it's approved by the commission, the agreement was within 30 days of guidance from the U.S. Treasury, which we're waiting on and we think could come out any time, that we would meet with ORS and or initiate a docket for this commission to consider how to flow those back to customers. And I think that will be something that we can think about, because it's, when I say hundreds of millions of dollars, that's going to be year in and year out. So we can potentially defer those costs and bleed those into rates over time to help moderate bill impacts. So those were some of the considerations that we had. We felt like 2 was a reasonable time period.
All right, thank you. That's all I had right now.
Mr. Callahan, I'm going to ask this question. You may not be the right person, and it may be somebody later, but just with regard to the bills, will the EDIT rider be a separate line item on the bill showing a decrease? And the reason I'm asking is the bill, or the energy portion and the, I don't think base rates are being changed. Is that correct? In this?
I honestly don't know the answer to that
Okay.
question.
Well, somebody else, when they come up, they need to remember to clarify me on that. I'm wondering if the energy portion of the bill will reflect any increases from this case, but then if approved, the EDIT rider would show as a deduction, so that in 2 years, that EDIT rider reduction would go away, and it wouldn't be like an increase in the energy portion.
I can talk a little bit about the bill format. So
Thank
we
you.
have a lot of flexibility. And we can talk through those things of how do we want that bill to actually look to help cut down on customer confusion and look at how we separate that or combine it. We have the ability to do either one, Chair Belzer.
Okay, just curious. Have there been discussions with ORS or DCA on that bill format to try to help alleviate customer confusion, depending on what comes out of this case?
We have not talked about that at this point, but
Okay.
we would certainly engage in those conversations.
I think my concern is that let's assume that the proposal is adopted and how that might come out. That's what I'm concerned about. If there's an increase in if it's kind of all hidden together in the energy component, of the charges and the mitigation through the EDIT, then it's going to be another shock to consumers at the end of the EDIT.
And maybe if I could, maybe subject to check. My understanding, I do believe that it is shown as a separate line item today because it is in a rider. And we've already been flowing back to customers tax benefits going back to the last rate case. So I do believe it's a discrete line item that will change over time, not just for.
And I'll admit, I should probably know the answer to this, but it's just come up with some of the confusion. That's why I was asking.
Understood.
So, thank you. Thank you, Ms. Hunsaker. Commissioner Caston.
Thank you, Madam Chair, and good morning.
Good morning.
You're blurry with these, but I can't read without them.
I understand. I have mine right here too in case I needed them.
Thank you. I guess along that billing question, I know Mr. Hall asked, a question about if it's, use 1,000 kilowatt hours to determine, what it would be. And I believe DEC has an inclining block rather than a declining block like DEP. Is that correct?
That is a
Inclining block, right?
better question for our rate design experts. I'm not sure.
Do you receive a DEC bill?
I do receive a DEC bill.
You live in Greenville, I know you do. Who will I ask?
Witness Beverage, Morgan Beverage.
Pretty sure I'm right.
I think you are too, subject to check, but I want to be entirely sure, and he is the expert.
I understand. I'm not. Just in case, do any of you know what the average residential consumption is?
At DEC, it's 1,073 per month.
1,070. You knew that. Good.
I did know that.
Appreciate it. Ms. Hunsaker, I believe most of these questions for you, but anyone feel free to jump in. Relative to page 36, lines 16 through 23, this is in your, I think, direct. You talk about AMI data combined with Customer Connect.
Can you tell me which page that is again? I'm sorry.
I'm sorry, page 36. I think it's lines 16 through 23. And I didn't quote it, but in general, I think you were talking about AMI data combined with Customer Connect and that sort of thing. And on page 5, lines 18 through 20 of your direct, you state the Customer Connect system helps better understand our customers' mindsets, motivations, and values. And you know, all the things I read yet, IVR, SAP, all these wonderful acronyms, and I kind of knew what they meant, and I've probably forgotten them now, but is the Customer Connect interface, or is it an interface or integration system for the AMI billing, the work orders? Is that what Customer Connect does?
That's a great question. So Customer Connect is the billing system. So your AMI data would flow into the billing system. The billing would come out of Customer Connect. So it's really what's taking all the interval data and those billing determinants and calculating your bills, you know, taking care of accounts receivable, the payments, those types of things.
Then what is the, I wrote the acronym down somewhere, but I don't remember I think it's Systems, Applications, and Products, SAP.
Right.
What is
so
that?
SAP is the billing system. That is the new billing system that we kind of branded under Customer Connect. And so that is the core billing system that we leverage today. AMI data feeds into that. That system then, and the data within that system feeds our IVR, you know, when customer calls in and they get the message, right? So that system and the data within that system feeds a number of interfaces.
Okay, I guess what I'm trying to get to, just for my edification, understand better.
Yeah.
Because fascinating reading, all that. With AMI meters,
Yes.
The ability to do many wonderful things, and one of those is collect data on usage, outages, length of outages, all kind of stuff like that. And to use that data and a host of other information you receive, to be able to mine that data, you have to bring all that stuff somewhere to be able to do that. What I'm trying to determine is that the Connect system, and it ties all those things together and provides the company the ability to mine data?
It does. It does bring all of that data together. There are different subsets of that data that go do other things, but that is the place that all the data comes together.
Excuse me, go ahead.
And we do so many things with that AMI data already, right? I think there's a lot of opportunities in front of us, but today, you know, we do usage alerts so customers can get a feel of what's happening. We can do same-day orders now, right? As we do that, we can ping when we're talking with a customer on the phone that says their lights are out or did my lights come back on, we can ping meters. There's so many things, and we've brought those all together and integrated those through Customer Connect or through the SAP system, so that we can help customers a lot understand usage.
And that kind of gets me to the next question, because, you know, when I read the part where you talked about understand customers' mindsets, motivations, values, and everything else, does this system, does it use algorithms based on customer usage patterns, data, phone calls, questions asked, and all? Does it use algorithms to try to help the company understand these mindsets, motivations, values, and such as that?
Yes. So some of that sets outside of Customer Connect. So when we talk about understanding customers, right, we use a lot of different kinds of data. We use what we get out of our customer experience surveys. So we get survey data, and customers tell us how they feel about different things. And so we take the experience data, we take behavioral data out of SAP. So is somebody past due, right? Does somebody typically interface with us through a call center, or do they interface with us through the mobile? So we take some of that data that we understand out of SAP, we bridge it with operational data, and that is where we get a lot of the mindset. We understand kind of how does that customer want to be interacted with, what's important to that customer, and then we start building that in either our digital or our phone, or with our phone systems that we have with our specialists.
Well, you know, some of the buzzwords today and acronyms, AI, in essence, algorithms to learn patterns and stuff.
Right.
Sounds a lot like AI. Is that a fair?
I would not say that we're using AI today. In that we're using a lot of data, but we are not using AI in that today.
Understand. Is the program proprietary, or is it, you know, developed by Duke? You guys own it? And what I'm trying to get to by proprietary, are you having to pay like an annual maintenance fee? Some other company developed this, and you guys acquire it.
Right. So for the SAP system itself, it is not proprietary, and that was one of the selling points, is because SAP is a company who has that same platform all over the globe, and so it continues to evolve. We don't have to invest in it like you would if it was a homegrown system, and so it is definitely not proprietary, and it is something that we pay licensing fees on.
Thank you. And in page 34, lines 6 through 7, you state the 148.9 million system. Was that intended to be 148.9 million system-wide, or?
Yeah, that 148.9 is through the period of January of 19 through June of 23, but that is for DEC North and South Carolina.
DEC. So the 148.9 is DEC, North Carolina, South Carolina, not DEP. Does DEP use the same system?
Yes, we use the same system for DEP.
So you're saying this 148.9 is the allocated amount for DEC, North Carolina, and South Carolina?
That's correct.
So the overall cost for this Customer Connect is apparently a lot more than 148.9.
That's correct. That's correct. So if during that time period, subject to check, it was, I think, around 420 million.
You exceeded my ballpark.
About that.
Estimated.
I do recall, Retha, that this was included in the Duke Energy Progress case. It was in service by the time we came in for that case.
And is that system used just for the total 420 for the DEC, DEP, North Carolina, South Carolina? Is it used for any other subsidiaries, Florida, Kentucky, any of those?
It's used for all of our jurisdictions.
Which makes sense. So the total cost for this system is roughly 420, and it's used by all of the Duke subsidiaries.
The cost for the system in that time period, yes. But the total cost for the system was greater than that 420. So the costs that we reflect in here are from January, subject to check, I believe they're from January of 2019 through June of 23. That's something that you might be able to validate, but I think that's what's in here.
Okay, so that includes the capital cost, the maintenance fees, O&M or whatever. I mean, from that last rate case, because I saw Customer Connect in the last rate case.
That's right. So that is all of the project cost within there for that time period, and those project costs would have included licensing fees and those types of things in the cost.
Okay. And knowing that all the other systems, subsidiaries use it, and it's probably much, much more than this. What I'm trying to, I guess, determine going forward, when's this thing paid for? I mean, when's it gonna be just a maintenance fee and maybe some O&M? That's what I'm trying to understand.
Yeah, subject to check, and I think maybe she can help me. But I believe this is the last of the project costs flowing in through this rate case.
And then
And then
it would
then
only,
it becomes a normal operating system. And any upgrades or whatever to that would just flow through normal process.
and that would mostly be just the annual maintenance fee and any O&M?
Correct.
Do you know about estimate what that would be?
I don't have that off the top of my head.
Okay. And
You're trailing off a little bit
I'm
at the
sorry.
end of your answers, and
Okay.
I need to be able to hear.
Okay,
Thank you.
thank you.
So just to follow up, Commissioner Caston, we do have, following up on what Witness Hunsaker said, we do have a pro forma in this case for the second tranche of the Customer Connect recovery. And with that tranche, that'll be the final amount that we are putting through for implementation of the system for DEC in South Carolina. So we had about $8 million that we're flowing through. Again, we had the first tranche. It was covered in the last case with respect to implementation of the system.
I remember seeing $6.6 million included in this also for, I can't remember if that was O&M cost or whatever, going back to the previous one. And I was thinking if that was the, I think 39 million, I think, was the allocated amount for South Carolina for the Customer Connect. And with the 6.6, it would be 45, 46, something like that. Is that correct?
Yes, we had 33.9 million of capital.
33.9, right, 34.
And then 6.6 million of O&M.
Okay.
Correct.
And all that information you got there, does it give an idea of what the maintenance fee and the annual O&M would be?
It does not, unfortunately,
And would
on a
anyone
going
have
forward
that?
basis.
I'm sorry.
I do not have that information on a going forward basis.
Would any of the panelists have that info by any chance?
I don't think any of the panelists would have that information. That is something that we could look at providing.
Chair Belzer, the company is happy if the commission would like to be able to provide a late file exhibit if that's necessary.
Well, I'm not asking for one. I was just curious, but thank you. Because I've been down this road before. Final question, I think. The Customer Connect in concert with AMI data and other data, and I think you've already answered this, but allow the company to identify and evaluate customer usage patterns, outages, length of outages, and such as that on an individual customer basis also, correct?
Yes. Yes.
Impressive. Well, let me look. Thank you so much. I appreciate it.
Thank you.
Thank you.
Vice Chair Powers?
Thank you, Madam Chair, and good morning to all of you.
Good morning.
It just occurred to me that three people to my left and I were elected at the same time, and we've been here for close to 4 years. This stuff's hard. This stuff is very hard, and I admire the work you do. I really
Thank you for that.
I wanted to point out that I admired the way everyone from Duke handled themselves in these 7 public hearings. I can imagine, Mr. Callahan and Kamal, that y'all really would have been happier somewhere else.
Well, you know, it's important for us to hear from our customers, and that's why we show up as 50 strong. We want to resolve their concerns. We take that back. We take that feedback and try to improve every day.
Well, I'm sure you do, and I think we heard from somewhere between the 70 and 80 customers, and all but 1 or 2 did not have positive responses, and I know that had to be hard to hear, and it was nice you had somebody there to help them with their individual problems. But the first thing I wanted to do, you know, being judges, they were all told they couldn't ask us questions. They had a lot of questions that were unanswered. And not doing this to embarrass anybody, but I really would like to, and any of you can take the questions. But there were several questions, this is full of everything they said, that they asked. One of them that kept popping up, and I noticed myself, there were, in the last few months, a lot of what I call generic commercials about Duke that really didn't address any problem or give any real information to ratepayers or to the public. Why were these commercials suddenly put on during this process of this hearing?
Well, first, I would say they weren't suddenly put on during this rate case. We often have brand campaigns, just general information on Duke Energy. Should point out that these are funded with shareholder dollars. They're below the line costs. They're not a penny of that do we seek for recovery from customers. But it's in recognition that we live and work in these communities. We're part of the community. I have 3,700 employees that work in South Carolina, 7,300 retirees. We just think it's important to be a part of South Carolina.
Okay. Well, I didn't mind the commercials because it cut out some of the lawyer commercials. The other thing that a lot of people, and some of these people were right intelligent, right smart, that they kept asking about, or they made the point, they said, when you come in here, you always ask for more than you want. And of course, your numbers, particularly, your numbers matched what you asked for. And they want to know, well, why do you do that? Or did you really think that's what you should get?
I can tell you that what we filed is what we really think that we should get. I think every dollar that's in there is a prudently incurred cost, including the cost of capital that's included in there. You know, we asked for a 10.5% ROE. I talked about who I view as some of our closest peers, why we felt like that was necessary. But to put that in perspective, you know, we did enter into the settlement agreement, and if it's approved by the commission, I think it sort of balances out what we recognize as our prudently incurred costs with a level that takes into account that balance with customers.
I just realized this sounds like I'm throwing softballs. Another thing.
It hasn't felt that way in the chair.
And of course, we get materials and we get confidential materials, and understand, but one of the things they kept raising is why aren't these public benefits, salaries, board of directors things, why are they not public knowledge in a publicly held company?
I think a lot of them are public. If you go and look at our proxy statement, you know, under the SEC regulations, our proxy statement has a lot of information on executive compensation. It certainly has information on board of director compensation. So I think it is out there. I don't know if it's necessarily in our filing, But it is out there publicly. Like you said, we are a publicly traded company, and we adhere to all of those rules and regulations.
Okay. And I realize too, and this is one I picked up on, and I think I put a little star on it, was someone else, they talked about, and I think the testimony, and it may have come through Mr. Robinson, was that salaries are high and sufficient to attract top talent. And I've looked particularly at your resume, and you're obviously top talent. I've got no doubt about that. But the question was raised, if somebody's making a lot of money, why would they need incentives to do the job they're getting paid for?
Now, I would say specifically on incentives, incentives are just part of our overall compensation structure. It's sort of the how we pay our employees. You know, interestingly, as you look at the positions of the parties in this case, no one took exception with what we are paying employees. It was how with the incentives. And we think it's important to have variable pay that's linked to performance, can drive behavior. You know, some of the metrics that are included in that are cost, which certainly accrues to the benefit of our customers, but we also include other metrics around things like customer satisfaction. And, you know, I think the results have spoken for themselves with J.D. Power and being top quartile. That has been a goal of the company and everyone's incentive plans. And I think it can help drive behavior that benefits our customers.
Okay. I think there's only a couple more of theirs before I get to my questions. The ratepayers, many of them, and I know a lot of it has to do with efficiency and different things with the homes and people who are living in poverty. But the ratepayers, even though, you know, the testimony is that the non-fuel O&M has been kept flat and no raises. Of course, there has been adjustments for fuel. Ratepayers consistently said rates have already been going up. Is that just due to fuel? I mean, have people been getting raises? What, you know, it seems like what they're saying is you already got your increase because my bill is now here rather than here.
Maybe Retha can help me, but I do think that the vast majority of it is fuel. As I mentioned, we were in a period, as we all know, when gas prices were high, and that went into effect, as I mentioned, over a 2-year time period. I think we're on the back side of that. Obviously, fuel prices can be volatile. Gas prices have been volatile, but right now they've kind of moderated back down to a quote-unquote more normal level.
Mm-hmm.
But as you know, we haven't had any base rate increases over that time period, so that would be the single biggest driver. There may be some other rider adjustments that come through on bills, but I don't think those are going to be the big drivers.
Yeah, I agree.
All right. And this may be Ms. Jiggets or one of you. Is it ethical to receive a return on debt? Is that part of what the return that the company's getting? Is it based on debt, not just on equity?
I'm not following your question. So I guess a component, the returns that we were asking for in this case included a piece that was related to debt and a piece that was related to equity. So when I talk about the return needed for our debt investors, it's the interest payments that we have to make. That's what I think of when I am talking about the components of the returns we're asking for in this case.
Well, I mean, is that the importance of capital structure, and the higher the equity, the more return that you expect on your revenue requirement?
So the revenue requirement is going to be the capital structure and the cost components, so the returns for the debt and the proposed ROE would impact the revenue requirement.
Okay. And let me, I may need to go back to you, Mr. President, but there was some testimony, I think even today, about the other states. You talked about Georgia, you talked about other states and their return. Of course, Georgia has, even with prices being, or costs being more than they were for their nuclear plant, they kept pushing. And, you know, sometimes we wonder why that didn't happen here, but the average is 9.8. You're asking for 9.94. What's wrong with the average?
I don't know what average you're speaking to there, but
Average rate of return.
over what time period?
I understand this. You these other numbers, you were talking about a year, I imagine.
Yeah, I was on mine. I was talking about what their current allowed is.
Well, that's what I'm talking about. I think the current average is 9.8.
The current average, and what I would say is there's a few factors I think you need to take into consideration as you think about our risk profile versus some of these other entities. As I mentioned, Duke Energy Carolinas operates 7 nuclear plants. There are a lot of entities in that overall average that wouldn't operate nuclear plants. We also operate in a region of the country that is prone to hurricanes and extreme weather risk, and that ability to attract capital so we can respond to storms as our customers expect us to. I know there's a lot of utilities that don't have that particular risk. So I think there are factors around why 994 would be very reasonable, even at an average of 9.8. And I know Witness Coin can certainly probably speak at a level of depth beyond that.
Ms. Hunziker, you talked, and I thought it was very interesting in your testimony and in your summary, you talked about these different programs. Let me see, it's different programs about well, I don't see it in my notes. Different programs that were being paid for by the government, by the different groups providing money, and one in particular, I wish I could remember the name of it. There was a program that seemed to be funded by some sort of charitable organization. I wondered, do Duke employees, do they contribute money to these programs?
Are you referencing Share the Light?
Yes.
Yes. So we employees can donate to Share the Light. Our customers can help other customers and donate to Share the Light. So, and then we match the funds. It's okay. We match the funds within that, and so our foundation also gives to Share the Light.
Which said another way is shareholder dollars.
Yes.
Okay. Well, that's what I was hoping to hear.
Yep.
That there was money coming from both directions.
Right.
It's a mix.
Yeah, when you look at since 2020, I think this is a really good number. Since 2020 through March of 24, we have given assistance through Share the Light of $1.75 million to our DEC South Carolina customers. So it is not insignificant. There are a lot of funds being given out to our customers through that organization.
But do employees have the opportunity, like you take out money for taxes, Medicare, et cetera, do they have the opportunity to contribute to that? Or, of course, I'm sure they have the opportunity to contribute United Way or whatever.
Right.
Do employees contribute to that fund?
We do have employees contribute to the fund.
Okay.
And that's something that we can support however they would like to contribute. I did a personal campaign throughout the company last year to try to raise money in the company for Share the Light. So
Do top executives contribute to that fund?
Absolutely.
Yes.
Okay. All right. That's all I have for now. Thank you very much.
Thank you.
Thank
Thank
you,
you.
Vice Chair. I know we have some more questions from commissioners, but we've been going a little over 2 hours, and I need to give the court reporter a break, and I need to give me a break. So let's come back at, well, I don't ever trust that. I've got 11:21 on my phone. Let's come back at 11:35, please. Look at your phones. Good morning and welcome back to the Public Service Commission as we resume the hearing in dockets 2023-388E and 2023-403E. All commissioners are present in the hearing room, and we will resume with questionings from commissioners, and I recognize Commissioner Carol Lee Williams.
Thank you, Chair Belzer, and thank you to everybody in this room. As Vice Chair Powers said, this is hard on all parts, and there's a temptation to speed through questions, and I'm not going to do that because our job is to balance what each of you in this room is representing. So I will try to do as Mr. Hall did and try to weed out some of mine and see if I can pick up pace at some point. But I'm going to ask the panel. I may use a few names, but I really want any of you to help me understand. But like Vice Chair Powers did, you'll see a number of mine are going to come from the customer public hearings. And one of the ideas that came, I want to say Spartanburg, but no, it wasn't Spartanburg, was the idea of whether Duke Energy Carolina considered the phasing of the increase and starting with the lower and then moving to a higher. And I understand the EDIT and what that does and the timing associated with that, but I also understand it from a human nature perspective. And we've talked earlier about the timing and getting people ready for that change. But without the EDIT, if you were phasing in a bill increase, would you have looked at a lower amount and a higher amount? Would that make sense, or does what did you think about that idea when it came up?
I mean, really, the EDIT was the single best tool that we had because we did know that we had a credit sitting on the balance sheet, as I said, customer money, and felt like that was a good way to help moderate the bill increase for a period of time. Phase-ins can be challenging. I know there's accounting implications, and I'm certainly a recovering CPA. I haven't been doing that kind of work in a while, but there are accounting ramifications to phasing in rates, particularly when you're bringing in new assets like a Lincoln CT plant that go into those considerations. So we felt like EDIT was the single best tool that we had available to help phase in rates, if you will.
Is there any way in which this increase in rates can be coupled with energy efficiency measures as tools? Is that anything that's been considered?
I'm not sure when you say coupled, but I'll
amplify it a little bit. Just a tool for helping customers manage what they're paying for.
So I would say that we have a lot of tools, and that's certainly top of mind. And first, I should start with, particularly for our most vulnerable customers, I think one of the really critical aspects of the settlement agreement is the $2 million in shareholder funding, $1 million going to a low-income affordability study where we can look at those kinds of options, then $1 million to energy efficiency weatherization, and with a specific focus on health and safety. So my understanding on the health side, for example, there's homes that have mold in it, and weatherization agencies can't go in and do the work. On the safety side, there's homes that don't have smoke detectors, carbon monoxide detectors. So for the safety of those employees, want to get that equipment in there. So that $2 million in funding, I think, will help. And then we have a number of EE and energy efficiency and demand side management programs. In fact, I think the Commission just recently approved several expansions of those programs. So I think about our income qualified energy efficiency and weatherization program. That's one that I think y'all recently allowed for some expansions there. We have things like the My Home Energy report. You certainly heard about that at the night hearing. There's always people that don't like that report, but there's also a lot of people that love that report. They get very competitive about it. We provide ideas around how they can cut their usage on those reports, and a lot of them take it to heart and do so and reduce their customer bills as a result. Then we have things like Power Manager. That's a demand side management program. You get bill credits for being on that program. Allows us to control your heating and cooling load. That offsets, as I said, with the bill credits, not only do they get some usage savings, but they actually get credits. And then power share for some of our CNI customers in a similar way. And that's another program that y'all recently approved some changes to, where we've got some curtailment options for non-emergency events and expansion of that program. I always hate saying this because it sounds like we're bragging, but our energy efficiency programs are more than all of the other utilities in the Southeast combined in our Carolinas utilities. So I think we have a really strong record of taking advantage of energy efficiency measures, getting the word out to our customers, and helping them moderate their bill impacts.
And just to follow up on that, is that last statement related to just DEC, or is that DEC and DEP?
I think it's both, but Witness Duff, certainly our expert on energy efficiency, and he can clarify that.
Okay. In looking at the settlement agreement, one of the things I wondered about is whether there is any kind of stay-out provision.
There isn't a stay-out provision as a part of the settlement agreement.
In 11A and B in the settlement agreement, what is the time frame applicable for 11A, which is the permanent one-time 17 million disallowance? Is that from the previous rate case forward?
No, the 17 million is respect to what we were asking for expenditures in this case. So it was costs from 2019 through 2024. So it's specific
yes,
to the
since
buck.
the last rate case.
Since the last
correct.
rate case.
Okay, thank you. You can tell there are elements of the settlement agreement that just need a little bit of clarification. So here's another one. This one has to do with the use of, in 11B, of the term permanent. Permanently foregoing recovery in this case and in future cases, coal ash cost of approximately $36 million on a South Carolina basis. What does permanently mean?
We brought forward $36 million of costs that were disallowed in the 2018 case. We brought them forward for reconsideration here. And we are saying that we will not pursue that amount any further, based on, I believe, a commission ruling from you all. Again, before this proceeding started, you said no, and so we're not going to pursue any other avenues of trying to collect that $36 million. So it
in
is
future
off the
rate
table.
cases.
Correct.
And nor will we appeal that decision.
Say that again.
And nor will we appeal that decision,
Okay.
therefore making it permanent.
Okay. And I think this is more about other coal ash costs, but it has to do with the question of permanent. Once a facility is closed, who decides when it's closed? Who decides if there's? I think this is a separate case. So forget 11B. This is more who decides when coal ash facilities are remediated, closed. How does that happen from a transfer of property if they are repurposed and sold? I'm thinking about that permanent question, but it's really very separate. And clearly with any of these, tell me if there's somebody else I should be asking about these, but we learned the hard way. It's better to ask you all the questions and let you refer them to someone.
I would definitely refer you to, we have a few coal ash witnesses coming up, including Jessica Bednarsik, that could probably answer that at a more detailed level. But with respect to the question of when is it considered close, I would imagine that there are requirements under the EPA, under, for coal plants that were operating in North Carolina under the North Carolina Department of Environmental Quality, and then certainly here for the coal ash basins that we've closed under the South Carolina DHEC.
In 12A, for the deferral of the debt return, it says the deferral will include a debt return only, and then parentheses, at the debt rate approved by the commission. Is that the debt rate identified that will be identified in the order associated with this case, this hearing?
Correct. And as per the settlement, we're proposing it be the 4.56%.
Okay. when you design rates to recoup from customers, does that reflect their use profile and their load profile? How is that factored in?
So questions about the actual design of the rates would be from Morgan Beveridge when he comes before you a little bit later.
This is a more general statement, and you all know this is not my expertise, so when I looked at the settlement, I look at the ROE versus the agreement not to calculate return on revenue on various deferrals and investments. Is there any rule of thumb that lets you, or any page in your testimony that lets us understand kind of the magnitude of those options? Because that's really the balancing question that's one of the balancing questions we're looking at. Does that make any sense?
Yes, I think you're asking if anywhere in my testimony you can see the impact of debt-only return versus no return versus a full WAC return.
Yes.
Unfortunately, I don't have that laid out clearly in one exhibit that shows you the impact of all those various options. What you would need to do is kind of lay the pro formas side by side and compare. If you looked at the individual pro formas, say for example, for the environmental ARO coal ash pro forma, if you compared the return columns between the two, you would see the impact of switching from a debt only to a full WAC.
And is there any kind of generalized order of magnitude which has more impact on a bill than another? And I'm thinking more deferral versus ROE rather than the question that you gave back to me.
Okay, so say that one more time for me.
So there's a return on equity that gives a certain amount. There's a deferral that has an impact as well on the bill. And is it better for it to be identified as is the impact on the bill greater from an ROE or a deferral, or are they just apples and oranges?
The deferrals themselves will have a return component as a part of what we're asking for in the case. And so you will see that built into the calculations. And that's why I was saying if you wanted to see the impact of changing the deferral in those pieces, you would look at it. There are further deferrals that are going to be in rate base. There will also be a return component associated with those deferrals during the amortization period as well.
Madam Chair, may I?
Yes.
Mr. Caston?
And I believe based on the question I heard from Mr. Hall and, my understanding of those things is some deferrals include O&M, not just rate base or some capital expenditure.
Correct.
And I think the question or discussion was, whether that's a weighted average or whether that is the cost of debt. And of course, those two things would matter. But I believe, and don't let me put words in your mouth, and I believe your answer was it kind of depends whether it's has O&M in it and or capital or not, and whether it's a weighted average or whether it's debt or whether it's nothing, whether there's no deferral. Is that kind of what we were talking about?
So as a part of the settlement, for most of the deferrals as a part of the settlement, we have agreed to a debt-only return during the deferral period. And for those items that are in rate base, we are getting a full WAC return. There was one deferral where we are getting no return at all. It was for the credit card fees during the deferral period. That particular deferral as well is not getting rate-based treatment, so it would not be subject to a return at all.
I'm going to switch gears to where I'm a little bit more comfortable. And this may be something you want to refer, but we've talked some this morning about ROE and adjacent utility providers. Can anybody speak to energy rates in the Southeast from adjacent energy providers?
I don't know that I know the exact rates, and I mean, as you know, there's lots of rate schedules, and
right.
comparing across can be challenging at times. I do know that our rates are below the national average. That's one of the things that we continually strive to achieve. But I don't know that I can talk to the specific rates in a Georgia or Florida, for example.
What about DEC, North Carolina to South Carolina?
I've not looked at their rates directly either. I would imagine they're somewhat similar. The other thing that can be challenging sometimes with comparing rates at a point in time is what has been the timing of these fuel changes. You know, DEC and DEP, we come in during different times. Same thing happens at other utilities. Have you entered into, like we did, the settlement where we're flowing that over 2 years for DEC customers? So it can be a little bit challenging. We try to moderate some of that, but I don't know the exact numbers for some of those other utilities.
Okay. This is kind of thinking about, and we've talked a little bit today about the customers talking about the confusion of bills and the impact of fuel changes on bills. And I wondered if the company had considered a more simplified process where tariff revisions are done in conjunction with annual fuel proceedings that might help going forward. That's a question that is irrelevant, perhaps, but this is my opportunity to talk to you in front of a whole lot of other people.
Would that be Morgan Beverage as well, in terms of rate design?
Okay. And I guess in thinking about that, did any tools for talking to customers about that, the variability of the rates, were there lessons learned from the customer interchanges that you had in terms of how you message the variable inputs as well as the variation in what a customer's paying?
We continue to work on that.
Okay.
Right. It's ever evolving, but we are doing a lot right now to try to put some tutorials on our website. We're also looking at trying to, we're going to be creating something where a customer can calc their bill, put their inputs in. So we're really looking at what we can do as we go forward to kind of meet that need. So I would say there's part of a forward look. And then what we're doing right now is trying to use the assets that we have, the web, bill inserts. We're also entertaining putting something in the bill that's a little bit more detailed to help customer understand the different pieces and parts of their bill. So we're working on it.
How has customer service changed related to delinquent accounts since the previous rate case? And I'm thinking about the impact of COVID, the charges for return checks. Are there late fees? How has the company addressed that? How has that evolved over the previous few years?
Yeah, so when I would think about customer arrearages are growing since COVID. Our customers are struggling to pay their bills. We are trying to balance our policies, and you kind of got an example of that with Ms. Bledsoe at the hearings, right? Those situations are situations that we deal with every day. So we have guidelines that would say, a customer can have an installment plan and have 2 of those. And if they're not able to keep those, then we would offer a 3rd one, right? But they would have to put money down. And that's kind of what you heard Ms. Bledsoe talking about. And it's hard right now. So we're really trying to find the right balance coming out of COVID. But as you try to balance that, the impact of that is having a little bit more arrears than what we had prior to COVID.
Ms. Hunzinger, I really appreciate your May 14th letter where you laid out the customers that have testified and those that you've been in touch with, and as well, both in the meeting as well as after all of the hearings. How do you engage with your customers when there's not a potential rate increase, when there's not a public hearing? Is that an element of Customer Connect? But clearly, people giving those kind of testimonies in a room of people is compelling, and with the resources that you have to respond to them. But how does that happen when there's not the intensity and the deadline and the publicity associated with it?
Yeah, so we engage with our customers in a lot of different ways. Mike's group, Government Community Affairs, they engage in the community, right, through different community events, and I'm sure he can talk about that. We have the call center if customers do call in and they have a question, right, we engage that way. We also, through some of our surveys, it's not through Customer Connect, but it is through our survey ecosystem. We survey our customers quite a bit. And if you look at customers in South Carolina, we have about 200,000 survey responses back from our residential customers. We have a little over 3,000 from our small medium business. So we hear from our customers, and they give us feedback. They give us feedback, everything from kind of a general perception of what they think of how they've interacted with the company over the last 12 months. We get specific process feedback from them. We send surveys out. So if a customer has had new service put in, so there's a process from the time I start service until I get my service energized, and we'll send them a survey to say, how did we do across that whole spectrum? And then we have surveys that we send out to customers that interact with us through our mobile app or our web to say, give us feedback. How can we make this web better for you? What do you expect that's not there? And we do the same thing when they interact with our specialist. So we feel like we've got a lot of opportunities to be able to gather that feedback and then incorporate that into those insights, right, into how we get better all of the time. I don't know if you want to talk about.
Can I follow up on that before?
Yeah.
What kind of response rate do you get to your surveys and to the follow-up? Because they're not mandatory.
Correct. We get, I don't know the number off the top of my head, but I do know that it is pretty significant if you compare it to regular surveys. Customers want to give us feedback, right? And that helps us. It helps us get better. I can get that number, but I don't have that off the top of my head.
It's better than the national average, which
It
is
is.
like, I don't remember exactly, but less than 20%.
Yeah.
Okay.
And then just supplementing, as Retha talked about, so I have a community relations team, district managers who live all across the state. I remember talking about this in the Duke Energy Progress case with some of the events that we host, like pop-up events, for example. These are events that, if you go back 5-6 years ago, we were trying to do events on our own, hold an event, try to get customers to come out. Did not see many customers coming out. So we quickly learned, but if we pair that up with a community event where there are going to be people, so farmers market, science nights at schools, job fairs, that we can get people out. We put up one of our own desks. We have people available in Retha's team to answer their questions and on the spot, work through and help resolve their problems. I mentioned for some of our smaller communities, what we call our power hours. We talked about Atlanta in the DEP case. I think I had said it was at the library. It turned out to be at the town hall. But similar for Duke Energy Carolinas, at a place like Fort Lawn, we would hold a power hours at the town hall. Someone from my team put up their hours, kind of like office hours. I'm going to be here for the next 3 or 4 hours to take your questions and work to resolve them. I think in the Lancaster hearing, y'all heard about our regional advisory boards. And I think there was a member of one of those boards. We have community leaders. We have a regional advisory board for Duke Energy Carolinas as well as Duke Energy Progress. And what we use those for, they're unpaid volunteer opportunities for community leaders really to give us feedback and for us to take and try to do something with that feedback. I also have a President's Advisory Council of leaders across the state, same type of interaction to figure out what are we doing that's working, what do we need to change. So I just say overall, there's a lot of opportunities for us to engage with customers. Retha mentioned our small and medium business team that's interacting with, you get outside of the residential space. We've got a lot of customers there too. Small and medium business would interact with more of those medium-sized commercial and industrial customers. And then we have a large account management team that handles some of the biggest employers across the state and, working through their issues as well.
Thank you. I want to go back to Ms. Hunsinger's response that she filed on May 14th, and a number of the, I think I counted about 22 persons who testified talking about vegetation management. And what I noticed was that a number of them had been serviced in 2015, and they were not due to be resurfaced for vegetation management, or not them, but the right-of-way, the area, until 2024. And so I wondered whether the company was looking at other resources that have emerged over time, like satellite imagery and just whether it's AI or whether it's just open source imagery, whether that provides an opportunity for greater efficiency as well as more closer to real time as opposed to 2015 information about the needs, the general needs. I imagine it doesn't replace in the field.
I would say generally, it's not my area of expertise. We do a lot of new things with technology. I think as Witness Guyton comes up later, I think he'll be able to help you with what some of those are.
No, I'll also say Witness Guyton can talk at a more detailed level, but I did want to point out is one of the provisions in the settlement agreement is around vegetation management reporting. This is something that was also in the Duke Energy Progress settlement agreement, where we would file at the beginning of the year, what is the plan in terms of the line miles that we're going to spray, maintain, and then on a quarterly basis, provide you all updates with how we're progressing against that plan.
One of the answers that was in the May 14th letter a lot was the benefits of the self-optimizing grid. Right. Would you mind addressing that kind of from your perspective? And then I'm happy to ask someone else later on, but I think kind of getting it at the big picture, something that the way that anybody on the street would understand it, either of you.
I'm happy to try as a non-engineer, and Witness Guyton can give you the engineering answer. My understanding is there's devices and automation that we can put on the system that allows us to effectively reroute power. So in the past, when we would have a power outage on a segment or a circuit, more customers would be impacted. With these devices, we can effectively reroute it to minimize the number of folks that get impacted by the outage. That's in layman's terms.
And I appreciate that. This has come up previously, but I want to dig a little bit deeper. I think it was in Spartanburg that we had a number of customers talk about the home energy report. I think, Mr. Callahan, you talked about the fact that people tend to love it or hate it, maybe. That's a generalization. But were there any follow-ups associated with that, with the people who, held it and said it wasn't worth the paper it was written on, and that kind of comment? How do you make those more effective, or are they an effective tool? How do you evaluate that?
Yeah, we continue to evaluate that. We do have opportunities for customers to opt out. And so if a customer is really just not happy about getting that, then we can opt them out of that. And that is typically how we manage that, because we do have customers that appreciate getting that. Could be something that Witness Duff could talk a little bit about as well, if you have more questions about that.
is another big picture kind of question that I want to understand a little bit more about, and that's the cost allocation principles. Particularly, just if somebody could cover sort of South Carolina cost allocation principles versus North Carolina. I dug into a manual that was in DMS, and but I really didn't, and I kind of looked for it in testimony, and if I missed it, just tell me who to ask it of. But I just, at a big picture level, want to understand how that, how you calculate that.
That's a question for witness Hager.
Okay.
She can walk you through all the details of how it's handled.
Okay. I'm bouncing around, but related to coal ash, and this you may want to defer, but what mechanisms does the company use to determine if a coal ash pond is closed or complete?
Yeah, I think that's a question that really witness Bednarsek could probably answer. As I mentioned on a previous answer, I'm sure it is in close coordination with our regulatory agencies, our environmental regulatory agencies, but I don't know the exact mechanics of how it is determined to be adequately closed.
Okay. And following up in a different subject, Mr. Callahan, how does your knowledge, how do you determine how you hire additional personnel to operate? You know what? I'm asking about personnel and equipment, and then I'm letting this one go. So one of the potential adjustments that ORS had was related to aviation expenses associated with the board. Can you elaborate more on what those costs are and how ratepayers benefit from those costs?
I'll try to speak to a little bit. I think that was addressed in the testimony of witness Sparrows, but I believe our board members had or provided transportation to meetings and things of that nature as it pertained to the company.
And I would just say overall, with respect to the board, we're a publicly traded company, and a board of directors is a necessary requirement of a publicly traded company. You know, they sit sort of in between our investors and management, provide oversight to management. And I think that the skill level that we have across our board, we have a number of folks that, for example, have nuclear experience. That's invaluable to our team. We have folks that have worked outside of the utility industry and can provide different perspectives from other industries. So I do think there are benefits that customers get from having a board of directors.
And I'll just like to add that as a part of the settlement, we did remove 50% of the board of director expenses in the case.
And then it says excluding aviation. Does that mean aviation's at 100%?
I think we adjust aviation separately already, so I believe that's why it said excluding aviation. Like there's already an aviation adjustment.
Is the 50% industry best management practice? Is it just a compromise? How'd you arrive at 50%?
I believe it was just a compromise.
Was that in the settlement or was it in the filing?
To the extent that you're getting into settlement negotiations, don't.
That's what I was trying to ask. Was it in our filing or was it in the settlement? I'm trying to recall.
So number 15 is the adjustment in the settlement agreement. And I'm just asking if 50% is a best management practice that you see in other utilities where there's a sharing of the cost, or is it just a settlement agreement?
So I'm seeing now now that you're pointing me to 15, it was a provision in the settlement, and so really don't want to comment on specifics. It's the totality of the terms that worked for all the parties.
Thank you. If anybody else wants to go, I could you the time to review and see if I've got.
Commissioner Thomas?
So basically, Commissioner Powers, Vice Chair Powers expressed thanks to the company for the people there at the night hearings and all the work that went into that. I would like to extend those thanks to Department of Consumer Affairs and ORS. There was a lot of support there from those organizations, and that's very, very much appreciated also. And additionally, just all the work that everybody's put into this case. It's, as we've discussed already, it's very complicated, it's a lot of work, and thanks to everybody for all the work that's gone into this. And I have just one little follow-up question. So we've talked a lot about fairness, and the fairness to the ratepayers and the fairness to the investors, which is kind of the underlying principle of this whole concept. And so, I mean, I would just like to ask, is that agreed by this panel, that that's the underwriting principle that we're shooting for here?
I absolutely agree with that. I think in my opening comments, I talked about, in the context of the settlement agreement, we believe that it provides the appropriate balance between the needs of customers as well as the needs for the financial integrity of the company, for investors, as you said. There's a number of provisions that do that, but yes, at the end of the day, it is all about trying to achieve the right balance.
Okay. And taking that a step further, the balance would be between the Duke companies itself. Duke, South Carolina is the entity that we're dealing with here, but it's part of the bigger family. And would you agree that it is important that Duke, South Carolina customers pay their fair share, no more, no less, of the overall company earnings? Do you see that as an important concept, outcome?
Yeah, there's no question. When you think about this utility, and Duke Energy Progress operates the same way. Both of them operate across the state line. We've got an integrated system that benefits both states because of the scale that we have, the ability to put assets where it makes the most sense. So as I think about Duke Energy Carolinas, for example, the Bad Creek Pumped Hydro Facility sits in the upstate because that was the perfect geography to build an asset like that, and it's one of the crown jewels of our system. We've got several nuclear plants in South Carolina, with North Carolina customers paying their fair share. Likewise, we have plants in North Carolina that are paid for by South Carolina. Witness Hager can certainly talk about the allocations as we talked about to ensure that it's fair between the two states, but want to be clear that our South Carolina customers are regulated by this commission, and we want to ensure that we do that in the appropriate way.
And in addition to what you just now said, the South Carolina and North Carolina companies are still part of the bigger holding company family. And would you agree that it is important that the Duke, South Carolina customers pay their fair share relative to the total holding company?
Yes, again, I mean, any costs that effectively are born in Duke Energy Carolinas, South Carolina would pay their fair share of those costs that get allocated to South Carolina.
All right. Thank you. Appreciate it.
Vice Chair Powers?
Just one more thing. I want to go back. You know, we talked a little bit about incentive compensation, and I know that it's the settlement includes provisions about that. But if it were just simply base pay, those amounts in base pay would be subject to the reasonable and prudent standard, would they not?
Yes, they absolutely would. And in fact, I would say if we didn't have incentive compensation, we would pay our employees a higher base salary, because the total compensation package that we target based on market, based on benchmarking with our peers, we pay at the median of market for any given position within the company.
Okay. All right, thank you.
Commissioner Carolyn Williams?
Thank you. And I appreciate my peers giving me the space to have some time to look at what remain of my questions. In the settlement agreement, it is 11A. Are there any, does that relate to any line item elements? Are there specific costs that are identified? And Ms. Jiggets, that may be identified in your exhibits?
To my knowledge, though, this amount is related to our bug plan, and it's specifically the adjustments that were discussed by ORS witness Whitliff.
Okay. Okay. And then would one of you talk about the on-bill calculator and the goals for that, or refer me to somebody else?
Is it the on-bill calculator or the bill calculator tool that you're asking about? Because I think there's a provision about the bill calculator tool that we would work with ORS, evaluate whether changes need to be made to that and have it implemented by the end of this year. And I think you mentioned the bill calculator tool.
Does the bill calculator tool exist today?
There is a bill calculator tool today. We want it to work a little bit different.
Okay.
We've been working with the ORS specifically around net metering.
Okay.
And so it doesn't work the way we want it to for net metering customers, and I think that's the bill calculator tool work that's ahead of us.
Does it work for time of use customers? Or for customers who are contemplating time of use and want to evaluate that?
It does not. It does not. So it's more of a customer can use. So there's two things I want to clarify, right? Just a little bit. So there's a bill calculator that you can go in, and if you're looking to say, I want to go on a new rate, so I want to go from a standard residential rate to a time of use rate, I can model that and see what that might look like, okay? And then we have a request, and this is what I spoke of earlier, to look at how do we help customers calculate their bill. That is what we're talking about here, so that if somebody is on a rate and they don't understand all of the different pieces that go into something that might be totalized, they'll be able to break that down and understand that. So that's the future work that's in front of us. Is that helpful?
So the bill what is the one that lets you compare your options?
Yep, it's the bill calculator tool.
Okay. And the on-bill calculator is going to focus particularly on net energy metering, or that's the goal?
I think that's the goal, yeah.
Thank you for the clarification. No further questions.
Thank you, Commissioner. I just have a couple of questions. And I think I understood this from the settlement agreement, but it's beating the dead horse of coal ash. So in 11B, where we talk about the 36 million and the permanently forgo, I just want to be clear that does that represent the entirety of what was previously disallowed from the 2018 docket on a South Carolina retail basis?
It includes the entirety of what we included in this rate case related to pre-2018 costs, yes.
Right, that had been disallowed previously.
That's correct.
Okay. And that will, that issue will end with finality under the settlement agreement, is that correct?
For that $36 million.
For that $36 million.
That is correct.
Okay. And Ms. Jiggets, I want to look at your attachment A, page 14 of 18 to the settlement agreement.
Yes, ma'am.
And this is just kind of a recap of all the items agreed to in the settlement agreement. Is that correct?
Yes, ma'am. This
Okay.
reflects all of the revenue requirement impact of all of the provisions of the settlement agreement.
Okay, and so when I look down at lines, I'm having to, used to be easier to follow lines. Line number 29
Yes,
on ROE,
yes,
and that's a $28 million adjustment.
yes,
And then the next line, 30, is capital structure, and that's 12.5 million.
yes, ma'am. So that reflects that the $28 million impact, that's the impact of going from the 10.5 proposed ROE to the 9.94 in the settlement.
Okay, and what I'm trying to tie back is that's approximately $40 million based on the change in capital structure and ROE that might, and I'll follow up with Mr. Lawyer, but if he testified, but that would reference the $40 million in his testimony, roughly.
Could be it, roughly.
Does that make sense to you? Let me ask you that, if the way I'm reading
Yes.
that. Okay.
Yes.
All right. Thank you very much. Any redirect?
Thank you, Chair. That actually skinnies down some of my questions, actually, on that one, so thank you. Good afternoon. I think last time I saw you was good morning, so good afternoon. I'm going to start off with Ms. Hunsaker. Ms. Hunsaker, do you recall some questions from Commissioner Caston around Customer Connect?
I do.
Go ahead. Do you recall?
I do.
Okay. And Ms. Hunsaker, can you, if possible, can you elaborate a bit more around the Customer Connect deployment, implementation, and deployment, which may provide some additional clarity around the 2018 cases as well as where we are today from a cost perspective?
Help me understand what you want me to.
Sure. Can you walk through the origin of the Customer Connect through the implementation, through the optimization, if that's possible?
Absolutely. So Customer Connect was, a big system, an enterprise system that we implemented. We leveraged SAP in the middle, and we had a lot of interfacing systems around that included in that big project. The project was a multi-year project in which we delivered on scope and ahead of on timeline. So it was successful from that perspective, and it provided customers with a lot of new capabilities. Some of those capabilities are the things that we've chatted about today. It's the ability to do same-day orders, to be able to take that AMI data in and ingest it, and then be able to offer new services to our customers. So same-day service, Saturday service, when you look at usage alerts, there's a lot of things that we were able to do from an IVR, which is your interactive voice response when a customer calls. We can now, as a customer calls in, if they're in line and they're on hold, we can ask them if they'd like us to text them different pieces. We can text their balance. We know that they're in there to learn their balance, so we can text that to them. We can text them a link to go in and do an order via the web if they choose to do that via waiting on hold. We have a lot of capabilities that we rolled out with Customer Connect to really advance the experience, and then it gives us a platform that is much easier to build upon as we go forward.
Thank you. And so when thinking about the 2018 case, as it pertains to Customer Connect, had we fully deployed at that point yet? Where were we in that stage, if you can recall? So
we deployed the last pieces of Customer Connect in April of 22. Yes. And then we had 1 year to kind of wrap up the deployment. So costs were within that mid-23 perspective.
Got it. So when you think about this case, can you just walk through, or not walk through, but when you think about this case, are the costs that are now before the commission for consideration primarily those types of costs due to the deployment that happened in the 2022 timeframe? Or the completed deployment in the 2022 timeframe?
Yes, they are.
Okay. Thank you. I want to turn to Eat It next really quickly. And Mr. Callahan, this question is for you, or questions. Mr. Callahan, did you testify in the DEP 22 rate case?
Yes, I did.
And generally speaking, do you recall some questions from the commission around the roll-off of the excess deferred income taxes in that proceeding around customer messaging?
I do remember receiving some questions, yes.
Do you recall that we had agreed to develop some messaging, especially as we got a little bit closer to the roll-off of Eat It?
I do. Thank you for that reminder.
Do you recall what they were, Mr. Callahan?
I don't remember the details now.
Could we do something similar as we think about this case and these Eat It costs?
Yes, we'd be happy to do so.
Thank you. I also want to turn quickly to fuel. And Ms. Jiggets, this question is for you, or Mr. Callahan, but I'll ask you first, Mr. Jiggets. Do you recall, Ms. Jiggets, when new fuel rates will likely go into effect for DEC South Carolina?
I believe it's November 1st.
Thank you, Mr. Callahan. And Mr. Callahan, I'll continue on with you. Do you recall some testimony that you provided just an hour or so ago around fuel rates potentially stabilizing, if not going down? Do you recall that?
I do.
And I understand we're not at November 1 yet, but can you just generally, from your perspective, do you know whether the fuel rates will go down or will stay the same or go up based off of current projections?
Based on current projections, it would go down. I don't have an exact amount. I know we have filed DEP. I think that was in the 4 to 5% kind of range. I don't have a number for DEC. But based on projections as we sit here today, it would be a decrease to the customer bill.
Ms. Jiggets, do you have anything else to add to that? Or? Okay. All right, thank you. Next thing I wanted to go to, Ms. Jiggets, these questions are for you. Do you recall questions from DCA's counsel with regards to return calculations in general?
Yes, I do.
Okay. I'd like you to help me break down, and so I understand when we think about this concept of return. I heard you mention, or did you mention the terms WAC at any point during this testimony?
I believe I did, yes.
Can you elaborate on WAC, what WAC is?
So WAC is our weighted average cost of capital, which takes into consideration our capital structure and the returns we need for our investors. So it would take into account the cost of debt and the cost of equity, which would represent what our investors expect as a return for providing us money to operate the business.
Okay. And Mr. Callahan, this question is for you. When you think about what Ms. Jiggets just said, do you believe that the two components that Ms. Jiggets talked about, the debt and equity, are those real costs to the company?
Yes, they're absolutely real costs. There are costs of raising the capital that we need to effectively front load these investments. It's not really any different than a mortgage on a house, right? Most people don't have cash sitting in the bank to go buy what is probably the largest asset they'll purchase. And so they go out to effectively the capital markets. They get from a bank a 30-year mortgage so that they can pay that off over time. And that's very similar to the utility model where we raise capital and there's a cost to our debt investors and there's a cost to our equity investors of raising that capital for customers.
Okay. And Mr. Callahan, did you hear some testimony earlier this afternoon around the settlement agreement addressing the return or carrying cost calculation, as we like to call it, in the case, for the deferrals in the case?
I did.
Okay. And so do you recall, or this is for Ms. Jiggets. Ms. Jiggets, can you explain a bit more what is the settle to resolution or treatment of deferrals during the deferral period?
Yes. So during the deferral period in this case, we have agreed upon a debt-only return with respect to amounts in the deferrals.
So when you think about the equity component that Mr. Callahan was just describing, what does that then mean when you think about that equity portion of the return calculation? What happens to that equity portion?
That return ultimately becomes a shareholder-borne cost because I'm not going to collect that amount from customers it will then be borne by our shareholders as a result.
Okay. And so I'm going to turn to deferrals here for a minute, a bit more generally. So when you think about the concept of a deferral, can you explain to me as generally what a deferral is?
Sure. Like for us in the context of this proceeding, deferrals are where we have come before this commission and we have identified that there is going to be a major initiative in terms of coal remediation costs, or grid costs, or significant expenses that we're going to recover that are not going to be included in the current rates that we are charging our customers. And so as a means to prevent earnings degradation before coming into a case, deferrals allow us to set aside those costs to then come before this commission in a rate proceeding like we're doing right now to request recovery of those amounts.
Thank you. And so based off of your explanation, does it matter whether it's an O&M expense or a capital expense if it's in the deferral?
It does not, because again, the amounts, in our opinion, the amounts are related to expenditures that are not being covered by current shareholders based on the rates that are being charged at the current time.
And so, Ms. Jiggets, following up on Mr. Callahan's explanation around real costs as it pertains to the deferrals, what then does it mean when the company requests carrying costs on those deferrals based off of the calculation, as you mentioned before, whether it's a weighted average cost of capital or in the settlement case, a debt return only?
We're again in that process trying to recognize, again, the time value of money with respect to our investors having provided us that money at a period of time, going back to say January of 2019, we are not collecting those amounts from customers and rates currently. So it's reflecting the fact that we have been advanced that money, we have spent that money to generate power for our customers in the meantime, and that return is to allow us to then compensate our investors for the money they have provided to us in the interim.
Thank you. Turning to coal ash compliance costs really quickly, recognizing what you provided already, Mr. Callahan and Ms. Jiggets, wanted to just make sure, to the extent that you know, Ms. Jiggets, I'll ask you first, are there any costs well, I'll take a step back. Can you explain to me, Ms. Jiggets, generally speaking, what are the types of costs that are included in the coal ash compliance deferral?
Sure. So it is my understanding that the costs in the coal ash compliance deferral are the remediation costs associated with closed or non-operational coal plants. That's what's flowing through that deferral at the current time.
Okay. And Mr. Callahan, this question is for you. To the best of your knowledge, are there any fines, penalties, costs associated with any prior environmental issues, fines, penalties, or any costs associated with, say, the Dan River spill or other expenditures such as that included in the deferral?
No, there's not a dime of costs associated with Dan River in terms of the cleanup, in terms of fines, penalties. As you mentioned, the costs that are in the coal ash deferral are costs that we've incurred since 2018 to close our ash basins in compliance with federal rules, the EPA, as I mentioned, in compliance with North Carolina Department of Environmental Quality, and doing so in a way very similar to what other utilities in South Carolina have done, either through excavation of those ponds to landfills or beneficiation.
So do I understand that to mean that these are full-on compliance-related costs for coal ash basin closure activities?
Yes, they are compliance costs required under those rules.
And to the best of your knowledge, Mr. Callahan, are these costs that are being recovered from other utilities within the state?
Yeah, so as I mentioned, I know that other utilities are excavating to landfills, and I know beneficiation is used. In fact, beneficiation, my understanding, the STAR technology that we use was invented right here in Lexington. I think Santee Cooper was the first utility to use that technology. So my understanding is other utilities are closing the ash basins in South Carolina in a similar manner to how we are closing ours. And to my knowledge, they're recovering that in customer rates.
And from your opinion, Mr. Callahan, do you believe that the settlement agreement resolves the coal ash compliance costs that are included in this case?
Yes, I do.
All right, I want to turn to another topic here, and these questions are still for you, Mr. Callahan. Mr. Callahan, from your perspective, well, you recall several lines of questions from DCA counsel, right, with regards to portions of this case?
Yes, I do.
Okay. I'm just curious, from your perspective, what is DCA's mission?
So my
Objection, Madam Chair, I don't understand how this is related to the scope of previous cross-examination questions or the commissioner questions, what Mr. Callahan's impression of our mission is.
Chair, it is absolutely relevant to making sure that we establish an understanding of the perspective of DCA when they ask their questions around the company's.
I'll allow it,
set of
but I think we understand
Sure.
DCA's role.
Thank you.
So my understanding is that DCA represents our residential customers.
Okay. And curious, Mr. Callahan, from your perspective, are they the only residential customer representative in this case?
No, they are not. I believe ORS's mission includes looking out for the public interest, which includes all customer groups. So certainly residential would be a piece of that, as well as commercial and industrial customers.
And Mr. Callahan, when you think about some of the other parties that are part of the settlement agreement, such as SACE, CCL, Vote Solar, South Carolina Small Business Chamber of Commerce, could there be any others that are included that represent residential customer interests as well?
Madam Chair, I still
Yeah, I
don't
think let's
understand
move along. Let's move along, Mr. Rollins.
Happy to.
Let's-
Not a problem. And Mr. Callahan, honing in on, as you indicated, the Office of Regulatory Staff, can you elaborate a bit more with regards to the ORS's level of discovery and testimony filed in this case?
As I mentioned in my opening comments, I think there was something on the order of 2,500 data requests that we received in this case. I know that the ORS's mission includes the charge to audit, and I think they executed on that in this particular case. We filed something on the order of 1 million pages of information in this case. So, yes, I do believe so.
Thank you. And Ms. Jiggets, were you directly involved in a lot of the discovery and testimony that was filed in this case as part of your review and participation in the case?
Yes, I was.
Okay. And you recall, do you recall Mr. Hall's questions to you earlier about return, EDIT, as well as the return schedules and exhibits that were provided as part of this case?
Yes, I do.
Okay. Just curious, based off of your experience and knowledge in the case, did the DCA file any testimony addressing EDIT, for example?
Madam Chair, I don't understand the relevance of the question subject to our previous cross-examination.
Chair, it is absolutely relevant.
I
He
think
asked us-
relevancy is my determination, but if you want to make your argument, you can.
Go ahead, Chair.
No, you can go ahead, just don't make my determination for me.
Yes, ma'am. EDIT, was EDIT included? Was there
No,
testimony?
you need to address his objection if you want to.
Yeah, I was happy to, Chair. Okay, I'm sorry, I didn't understand what you had said. Chair, this is, again, the DCA asked several questions around the calculations included in this case. I'm simply trying to understand the basis for those questions and how they were derived based off of what was included in the case so far and what was filed by the DCA.
Very briefly.
Sure.
She can answer briefly.
To my knowledge, there were no questions about the EDIT that were presented to me for response.
Thank you. Do you recall them filing schedules in this case?
Madam Chair, I don't
Okay,
understand the
I'm
relevance of
gonna-
these questions.
Let me ask this question. Did DCA ask for all of the discovery that was provided to ORS?
Yes, Chair, they did.
Okay, then they got it. Let's move on.
Okay. Do you recall how many witnesses DCA filed in this case? in
Madam
terms of
Chair, I do
testimony?
not understand the relevance of how many witnesses the department has. There are a lot of issues in this case, and there are a lot of ways to
Yeah,
make a
let's-
case and to raise issues, and whether
I
or not we have
sustain. I sustain.
Okay, thank you, Chair, no problem. So, Mr. Callahan, I'll go back to you. When you think about the settlement agreement itself and the parties represented, How do you view the compromise that was provided and sent and submitted before the commission?
Madam Chair, I think we're getting repetitive now.
We are. This is redirect. It is to bring out new information or to address new information that was brought out on cross or from the commissioners.
Chair, the DCA asked a lot of questions about the settlement agreement and what it was laid out, as well as the commission. I'm just simply trying to provide some additional
I believe
context.
Mr. Callahan gave his opinion on the settlement agreement numerous times.
Okay, that's fine. I have one more question, Chair. We heard from several of the commissioners. Mr. Callahan, do you recall hearing from several of the commissioners that this is a hard case?
Yes, certainly heard that, and I couldn't agree more.
Indeed. And Mr. Callahan, with that understanding, can you please provide your view when you think about a hard case, what a settlement between diverse parties does?
Madam Chair, again, we're talking about the value of a settlement. I think that's been covered over and over.
Chair, the commissioners talked about the hardness of the case, and I'm simply continuing to provide to put it in perspective. That's all.
Very briefly.
So, as you mentioned, cases like this are complex. There was a number of issues that were fiercely contested between the parties, and the settlement agreement was an effort to arrive at something that could balance the needs of all of the interests, everybody giving and taking, concessions made, and arriving at an overall package that, like I said, balance the needs of customers with the needs of the utility.
Thank you. No further questions.
Thank you, Mr. Robinson. You through?
I am, Chair. I didn't know if you had anything else.
Ladies and gentlemen, thank you for your testimony and your appearance here this morning. You may stand down.
Thank you.
We're kind of getting at a point where I think we can break for lunch. Let's come back at 2 o'clock. We're going to go a little later than 5 today. We got a lot of ground to cover. And so taking into account everybody's needs. But if we have to take somebody out of order this afternoon, can y'all notify me of that at the beginning when we come back at 2?
Yes, Chair. Chair, also at this time, we would ask that Ms. Retha Hunsaker be excused.
Subject to my normal warning that, but that's at your peril. So, thank you very much. We're in recess until 2 o'clock.